pertaining to a removal from service without holding any disciplinary action. This case is at par with the Ayush Tomar, which was decided by your lordship in the month of March. So therefore, listing of this matter.
Listing for what?
Listing for a final hearing, your lordship.
After a week. After a week.
Or any short date. Your
After a week. That is the shortest. Yes. Yes.
All funding cases more than 10 years, item 1 and 2.
May it please your lordship.
Yes.
Madam, this matter relates to non-payment of gratuity of the petitioners, my lord,
Society.
who had retired from Jyotishitravan Film Studio Society, my lord, long time back.
Hmm.
My lord,
When did he retire?
my lord, on numerous days, my lord.
On numerous days he
My
retired.
lord, there are a lot of petitioners, my lord. So, my lord, the dates are indicated in paragraph 5, my lord. Paragraph 5 of the petition, my lord. My lord, the petitioner number 1 retired.
So a number of petitioners are part of this.
Are part of this.
There can be no mandamus to pay gratuity. Only the direction can be to consider their
Lordship,
case.
that may be there, my lord. Because this honorable court in a previous date of hearing, my lord, directed me to, my lord, obtain the instruction or the rules, my lord, that how the Payment of Gratuity Act is applicable to the societies, my lord. To this effect, we have filed an additional affidavit, my lord. If your lordship peruses the order also.
Just 1 minute. Please take your seat. Just 1 minute.
Oh, I found the error.
Yes.
Lordship, if I'm not mistaken, Lordship has perused the 26/4/2022
Yes.
order, my lord.
Yes.
My lord, prior to that, one other order was passed, my lord. Lordship may kindly take up my additional affidavit, my lord. This is the last affidavit. My lord, I have annexed the previous order of this honorable court, my lord. Page 10 of that affidavit, my lord.
Additional affidavit filed on 15th September 2000.
Read petitioner. Page 10 of that affidavit, my lord.
Yes.
My lord, learned counsel for the petitioner contains on 25/2/2020, it was passed, my lord. For the petitioner contains that the petitioners herein were former employees of Jyotishitravan Film Studio Society. By this writ petition, a claim is made for payment of gratuity upon their superannuation from service. Payment of gratuity is provided under the Payment of Gratuity Act 1972. Section 1(3) of the Act provides as follows. It shall apply to A, every factory, mine, oil field, plantation, port, and railway company. B, every shop or establishment within the meaning of any law for the time being in force in relation to shops and establishment in the state in which 10 or more persons are employed or were employed on any date of the preceding 12 months. C, such other establishments or class of establishments in which 10 or more employees are employed or were employed on any date of the preceding 12 months as the central government may by notification specify in this behalf. Apparently, reading section 1(3), it appears that in order to come into purview of payment of Gratuity Act 1972, Jyoti Chitravan Film Studio Society would have to come within the meaning of any of the provisions of section 13A to 13C. For further deliberation, an adjournment is sought for to examine under which clause the entity Jyoti Chitravan Society has can be worked into. So, my lord, we did some research, my lord. Now, I would like to place page 17, my lord, is a gazette notification, my lord, of Government of India.
Page 17 of your
Of
additional.
the affidavit, my lord. Annexure H.
Yes,
Lordship may have page 18,
yes,
my lord, SO statutory order 2218, my lord.
yes.
In exercise of the powers conferred by clause C of subsection 3 of section 1 of the Payment of Gratuity Act 1972, the central government hereby specified the trusts or societies registered under the Societies Registration Act 1960 or any other law with respect to societies for the time being in force in any state in which 10 or more persons are employed or were employed for wages on any day as per the preceding 12 months as a class of establishment to which the said act shall apply with effect from date of publication of this notification in the official gazette. So, my lord, societies have been brought under the purview of this act now. Now, the fact that the Jyoti Chitravan is a society, a government society, that certificate, my lord, I have annexed in the additional affidavit itself, my lord. Lordship will find it page 12, my lord. This is a certificate issued by Commissioner and Secretary for Cultural Affairs, my lord, Department of Government of Assam, page 12, my lord, Annexure E. This is to certify that Jyoti Chitravan Film Studio Society is a government registered society functioning under Department of Cultural Affairs, Government of Assam, with registration number 59 of 7374. The society has been receiving regular grants in aid from the Government of Assam. So, my lord, the primary objection that was taken by the respondents in the affidavit, one, that it does not have any state control. That has been taken care of. Even the secretary is appointed by the government, my lord. Government has deep and pervasive control in the society. Secondly, my lord, the act, to bring the scope of the act to this society, my lord, this statutory order, my lord, that is I have just now shown the gazette notification, will be sufficient, my lord. Now, my lord,
Yes.
the governmental control can also be established from a perusal of Annexure F, my lord, page 13 of the same affidavit, my lord. It is a letter issued by the Director of Cultural Affairs to the Principal Secretary to the Government of Assam, my lord, asking for fund for the society, my lord. Your lordship peruses page 13, my lord. I have the honor to submit here with the proposal amounting to 78 lakhs only as grant in aid to Jyoti Chitravan Film Studio Society for employee salary of Jyoti Chitravan during the year 2012-13, a copy of my lord. So, my lord, in this case, I respectfully pray if the government is directed to make the funds available to the society, the government is also party in the writ petition, my lord. So, the petitioner's grievances will be, my lord, redressed.
Payment of gratuity accorded. Yes, what do you have to say, Mr. Sharma?
Otherwise, this is my stand on the affidavit is we are a society under the Societies Registration Act. So we are not under the direct control of the government. But yes, it is a fact that we are getting grant in aid from the government. And the governing body has people from the Cultural and Affairs Department. That is a fact. Now, regarding the payment of gratuity, I fully subscribe to my brother regarding that provision of the act, that societies come under the purview of gratuity. But the practical difficulty here in this case is Jyoti Chitravan otherwise do not have any that kind of a provision for gratuity. Neither a sanction is there, neither some recognition has been there from the government, nor the society has got any pool or anything to pay for this gratuity. In fact, our salaries are presently being paid through granting aid. So we are in that kind of situation, Lordship. So if Lordship devises a way out to direct the government for payment, then I will have nothing to say, because ultimately they are our employees. But as presently our situation of society is that for salaries, in fact, we are getting it from as granting aids from the government. This is our position, Lordship.
And who's for the government?
And one more aspect of the matter, Lordship, regarding gratuity, if a Lordship has taken up the gratuity act, there is a controlling authority. And section 7(4)(a) provides that in matters of dispute, it is that authority who has to be approached. So that alternate dispute resolution mechanism is also there.
Yes, that is what I wanted to
Madam,
ask
that
you.
will come into, in my respectful submission, that will come into the picture once the gratuity is paid and some employee is not getting it. Then the dispute redressal mechanism will come into. Here is a situation, my lord, the government does not have any policy, and as submitted by my learned friend.
No, Mr. Rahul,
Lordship,
let us assume that your clients are entitled to payment of gratuity.
lordship,
Now, if an employee is not paid gratuity
lordship,
as ordained by the Act,
lordship.
what is the remedy prescribed by the Act?
Well, had it been
7(4)(a).
regularly paid to the other
No,
employees?
I'm asking what is the remedy?
My lord, in this case, in principle, since it is not been paid, my respectful submission, a writ will lie, my lord.
If a Lordship will read the
You're
language
not
of
answering the
4A,
question. Can you answer it?
yes, your Lordship.
Where is it?
4A, the admissibility of the claim is also a matter that is under the purview of the controlling
For the
authority.
claim, my lord.
4A. If there is any dispute to the amount of gratuity payable to an employee under this act, or as to admissibility of any claim. So he is making a claim now, whether his claim is admissible or not.
That the writ court will decide.
No, that the controlling authority will decide.
Actually, we don't have the power.
Writ court always have the power, plenary powers.
Hmm.
But I am saying it may be exercised in a cautious manner as the act provides for a provision. Because 4A language is admissibility of the claim. So here is the claim, the admissibility also comes in the purview of the controlling authority's jurisdiction to adjudicate.
No, but you are saying they may be entitled, but there is no money. Then
That is fact. My instructions is that the society doesn't have any money to even pay the salaries.
where is it stand in the affidavit?
Yes, Lordship. If your Lordship takes up my affidavit filed on 1/12/2011,
Yes.
Lordship will come to paragraph 6
Hmm.
regarding our financial situation, our position. Paragraph 6.
Yes, please.
That the respondent begs to state that the main objective of society is production of Assamese film as well as other local films in the region of the studio. The revenue earned by the society is too meager for payment of monthly salary to its employees as well as maintenance of its studio. Presently, approximately 7.5 lakhs is required for monthly salary of the employees, whereas the revenue earned by society is hardly 2 lakhs per month. Accordingly, society has to depend on granting aid received from the government of Assam. Presently, 41 employed societies are yet to receive their monthly salaries from August 2011. It is pertinent to mention here that in the past and the present employees are covered under the Employees Provident Fund, and on retirement, they get their Provident Fund from the Employees Provident Fund organization. And
So they are getting EPF.
yes, they are getting EPF. Employees Provident Fund, they have. And regarding Lordship gratuity,
Hmm.
paragraph page 5, paragraph 10, our stand. I'm just placing our stand. Paragraph 10.
Hmm. Yes.
The deponent states that the area DA of all the petitioners were already paid to them. So far as gratuity and leave encashment is concerned, there is no such provision in the society for paying the same, except 6 months salary is paid to them as a retirement benefit. So this is how the society has been functioning. In fact, to meet the salaries, there is a deficit of, in 2011, there is a deficit of 4 lakhs rupees, approximately 4 lakhs rupees.
So he is claiming gratuity and leave encashment also.
Well, I don't think he's claiming it now.
I'm not claiming it now, my lord. It's long time in 2010. Some of them have expired also.
So the issue
my
is
lord,
gratuity only as of now. The live issue
gratuity will
is gratuity.
suffice, my
Some of the petitioners have expired.
One or two have expired. My lord.
How much time you want to file application?
My lord,
I can't hear a writ petition filed by dead people.
my lord,
You know the law, Mr.
No, sir, I know that.
Yes.
but I will file it within 1 week, my lord.
If we strike off, then they'll not get the benefit.
Lordship.
Otherwise, their legal heirs have to come. Who have expired?
According to me, my lord,
Hmm.
According to the very
my lord, recently, my lord, one has expired, my lord. I think three has expired, my lord, I was told. But one is very much alive, my lord, one is there. Two is alive, my lord. Three, my lord.
You are not aware who is alive.
Three, I was told, my lord, that he has expired, my lord.
But you'll have to substitute, otherwise right to sue survives here.
Lordship, yes.
Or is it not necessary?
It will, my lord, actually, it's, if it is a common direction issue, then, my lord.
Even if one of the petitioner is no longer alive, then also it can be done.
I'll substitute him then.
So what is it? Be clear, what is your stand?
My lord,
You are a very seasoned
my
counsel.
lord, since it is a, my lord, it will be a order not in personam but in rem, my lord,
Hmm.
governing all the employees of society, whatever.
So
lordship
you are
holds
saying, even if some of the petitioners are dead,
That, my lord.
even then the High Court can hear and
My
pass the
lord,
order.
at least,
Substantiate that argument. Please,
my
sir.
lord, since the lords, whatever lordship will rule today, because the object section here is in principle, it is not given, my lord, to any of the employees because they do not have any corpus. They do not have any provision for payment of gratuity. Till that, none of the employees have got gratuity. Had it been that only these selected petitioners are not getting gratuity apart from others, then the question of my lord substitution would have been taken.
Otherwise, even if one of the petitioner is dead, the court can proceed and pass an order. That's your submission.
No, not in whatever lordship will deal, my lord, will be in rem, my lord, because insofar as the
Oh, I am asking you, is it your submission that during the pendency of the petition, one of the multiple petitioners have died, but ignoring that fact, the court can proceed and pass an order, even in favor of a dead person?
my lord, they substituted. Better it will be.
You are not sure.
No,
You want to get rid of this matter at the earliest.
my lord,
That's why you are making these arguments.
my lord, there's not, my lord, it's a long pending matter. It has been
So
passed
what?
on many occasions.
How can a dead person's petition be allowed by the report?
Uh-huh. I will substitute it. Or otherwise, I will make a prayer for, my lord, if no legal error is coming forward, then lordship may strike off.
That's right. You want to make that prayer today, you make that prayer. We'll strike off.
My lord, I have to bring out the exact who have expired. Some of them have, my lord.
The whole order.
Well, actually, my difficulty with me is that, my lord, the clients
You
are.
know it, but you are not admitting it. The order passed in favor of a dead person will be nullity in the eye of law. That is the law. And we are not going to pass such an order.
Lordship.
At least the judges know a little bit of law. How can you ask for an order in favor of a dead person?
My
After
lord, yeah, I will substitute or I will ask for striking off. Let me take the instruction, my lord. Who have let me post it, my lord, immediately next week, my lord. I
Hmm.
do that, my lord.
Mr. R. Gautam, learned counsel for the petitioner, submits that during the pendency of these writ petitions, some of the petitioners have expired and no substitution of the legal heirs have been made till today. However, in order to ascertain the particulars of the legal heirs of those petitioners who have expired, Mr. Gautam pays for posting this matter again after 10 days. Mr. A. Sharma, learned counsel for the respond numbers.
2 and 3.
Then you write Mr. R. Dhar, learned additional senior government advocate for respond number 1.
Item number 2.
Mr. A. Sharma for respond numbers 2 and 3, and Mr. B. Chakraborty, learned CGC are present.
Also for the accountant. Standing council account.
Learned CGC appearing for the accountant general also are present on behalf of the respondents. On the request of learned counsel for the petitioners, these matters are directed to be posted again after 10 days. We file an application for substitution and then we'll proceed. We can't pass an order which is nullity in the eye of law.
Obliged, Lordship.
All right.
Item 3.
Lordship, may I please this matter will pass over for the time being. Just for 5 minutes, Lordship, he is on legs.
What is this matter?
Lordship, here the petitioner is seeking a out of turn promotion of his.
No, the petitioner is seeking promotions under the unqualified quota, which he was denied at the relevant point of time. My lord, may I just give two?
Yeah.
Short list of data will explain the issue.
Yes.
Well, there were two persons, the petitioner and one Mr. R.M. Dhote. The tabular form I've given, petitioner had joined the services in 1989, R.M. Dhote had joined in 1988 in the same post. Thereafter, my lord, they both qualified the required promotional course for the promotion to the rank of the head constable. Thereafter, my lord, lordship will find at the fifth row, they both were engaged in an anti-terrorist strike, and both were constable general duty at that point of time, and both were recommended for promotions under the 10% unqualified quota to the rank of sub-inspectors. Now, my lord, thereafter, while the petitioner was promoted only to the rank of head constable general duty, to which he was already qualified, R.M. Dhote came to be promoted to the rank of sub-inspector in the force. The reason given by the respondent authorities was that on the date of incident, I was a constable general duty. Therefore, I could be given promotion to the rank of head constables ahead of my peers. While for the case of R.M. Dhote, since he had already been regularly promoted to head constable general duty on the date of promotion, therefore he was given the promotion to the rank of sub-inspector. For me, the consideration date is the date of the incident. And because I was already qualified for the rank of head constable general duty.
What is the date of incident?
The date of the incident is 23/6/2005.
They are still in service.
Yes. Yes, the other person is now serving as an inspector, while petitioner is still serving as a head constable.
Who has sworn the affidavit here?
My lord. Well, he was a nephew of the petitioner because the petitioner at that particular point of time was in service excellency. He was in service, my lord. He could not come to swear the affidavit, but under instructions, his nephew has sworn the affidavit in the writ petition. And in the affidavit no position, my lord, it has been sworn by the DIGP, my lord. This only record.
Service matter, nephew can swear affidavit.
My lord, everything is here on record. The entire case of the petitioner is on record, my lord. Nothing to do with the personal knowledge of the case, my lord. Because it is only on record that the matter is being proceeded with, my lord. Because it is not a case, my lord, that I had done this or this was informed to me verbally. Nothing of the sort, my lord. It is only the letters and the rules which is placed.
Right, now these dates are not very clear here. You say that the petitioner and R.M. Dhote,
Yes,
they joined in 89 and 88 respectively.
my lord, yes.
Then they cleared the promotional examination
Yes, my lord.
and was brought on the approved list of
2004.
A/GD/8. What does it mean?
My lord, A is the what is A is the name nomenclature they give to persons who are supposed to be qualified for promotions from constable to head constable, vis-a-vis the vacancies already available for such promotion. That is the A list. That is there in the rules, my lord, I will show. So he was brought in on the A list in 2004. Rules say that he could only be brought on that list if there is a vacancy vis-a-vis which he can be promoted. So he stood promoted, the promotion order was evaded. Only that part was evaded. Then, my lord, he was given the financial upgradation on 18/8/2004.
without issuing the promotion orders. Till that time, my lord, there is no difficulty. Then, my lord, on 23/6/05, they both get involved in the incident together when they are still serving as constable general duties. Then RM Dhote's promotion to the rank of head constable was released on 23/8/05, 2 months after the incident. Because on the AGD list, he would be senior to the petitioner. He joined in 88, so he would be 1 year senior. His promotion got released earlier. Then, my lord, I was promoted to the rank of head constable on 19/10/05 under the 10% lordship will find unqualified quota. And on the same day, he is given promotion to the rank of sub-inspector under the 10% unqualified quota. So, my lord, case of the petitioner now is that we were both constables on the date of the incident. We were both qualified to be head constables on the date of the incident. The very promotion is a promotion for unqualified quota, which means that I am not qualified for a particular post and I am taken to that post. For me, at that point of time, the unqualified post remained sub-inspector. I was qualified for head constable. So my unqualified post would be sub-inspector. And for Dhote also, it would be from constable, it would be
But
unqualified.
your promotion to head constable was not notified.
My lord, the moment I'm brought on AGD list, it has to be against a relevant vacancy which already exists. Otherwise, I would not be there. The only question of release by this directorate on that release order was to be given that you now become a head constable. For RM Dhote, when he is taken to the post of head constable, it is under the qualified quota. He was already qualified for that. So the unqualified quota became sub-inspector, to which he was not qualified at that particular point of time. I was qualified for head constable, so 10% unqualified would mean I would be at the rank of sub-inspector because I was qualified for head constable. It would come to me in any course of time, it would usually come to me. And while passing the orders, original orders, there is no such consideration that RM Dhote is a head constable now, so therefore you take him up to the sub-inspector rank. That is only when I give them a legal notice, they first draw up that ground saying that he was head constable on the date of promotion. For him, the consideration date is the date of promotion to the rank of head constable. For me, they keep it at the original place.
Right, you substantiate your case, please.
My lord, yes. Lordship will kindly have the my lord, I'm not going to the incident part, my lord. I'll just come to page 26, my lord. Page 26, my lord, the office order by which I was promoted.
Yes.
This is the order by which I was promoted. Consequent on his allotment on out of turn promotion under 10% unqualified quota of this unit, Sri so-and-so has reported on his arrival at TC Jammu on so-and-so. Accordingly, he has been taken at the strength of this unit on 15/3/06. Next. Number so-and-so, Constable GD Madhav Damasudra was already qualified SCC serial number 26 and brought on special approved list AGD 8 of 24 by 14 5 Battalion CRPF on the date of his gallant action against the Naxalites in Bihar on 23/6/05. He also has been allowed first financial upgradation under ACP scheme with effect from 18/8/04 in the pay scale of so-and-so, White 45 Battalion, order number P8505 ESTT1 dated 18/2/05. Since he had already qualified for promotion to the rank of head constable general duty, his case for out of turn promotion to the rank of SIGD was taken up with the competent authority by 45 Battalion CRPF. Additional DIGP Directorate General CRPF New Delhi by signal number P8175 dated 8806 has intimated that since the individual was constable general duty on the date of incident in Bihar on 23/6/05, he granted out of turn promotion as head constable general duty with 19/10/05, thereby becoming senior to thousands of constables of his batchmates for relative seniority among those qualified in SCC serial number 26. As such, he got his due and cannot be considered for out of turn promotion as SIGD.
So you have already got one out of turn promotion.
No. The question was not of out of turn promotion, madam. The question was of 10% unqualified quota, which I will show from the rules, is a promotion which is given to a post for which I am not qualified.
So why was that promotion given to you?
The 10%,
Out of
they
turn.
say that I had already qualified, but we are giving you a out of turn promotion only.
You are contradicting yourself. I just now said out of turn promotion.
Yes.
You said it is not out
No,
of turn.
the promotion that was required to be given to me was under the 10% unqualified quota.
Correct.
They restricted it to out of turn promotion, for which I was already qualified. Therefore, my promotion given to the head constable will not fall within the definition of 10% unqualified quota, is the case, my lord.
But why was it given out of turn?
They say it is because of my gallant action.
So unqualified quota would also be because of this reason.
Yes,
So for same reason, whether you call it out of turn or unqualified, you have already got promotion to head
yes,
constable.
yes, I've got a promotion.
Then you want the second promotion also
No,
on the same card.
I wanted to say, my lord, that out of turn promotion to the rank of head constable general duty does not suffice the conditions of giving me an out of turn promotion under the 10% unqualified quota. That promotion should have been to the rank of SI, as given to Mr. R.M. Patel. Because he was a constable on the date of the incident, he was qualified for head constable, and they promoted him to the rank of SIGT.
On the date of incident, both of you were.
Both were constable general duty, my lord. Both had qualified for head constable.
And when was Dhote promoted as head constable?
On 23/8/05, 2 months after the incident.
And you were promoted on?
19/10/05. And on the same day, Dhote was given the promotion to sub-inspector under the 10% unqualified quota.
And Dhote's promotion to HC was also under unqualified
No,
quota.
it was regular because we had both qualified for the head constable. His promotion was released on 23/8 to the rank of head constable on regular basis.
What is the dispute? You got one promotion out of turn or
Yes.
10%, whatever you call it.
Yes,
He got one promotion out of turn or 10%.
yes.
He was senior to you in service.
But otherwise, we being in the same rank, otherwise we being,
No, there could be people in the same rank, but there are other criteria which will come.
but for a 10% unqualified quota
Hmm.
on the same incident with the same merit, my lord. When one person goes from one to the next, leaving behind, leaving one post blank, when he goes to the second post and keeping me below.
Mr. Mazumdar, just hold on for a minute. The question of this out of turn 10%, these would not arise. These would not have arisen unless you were a part of that incident with the encounter with the Naxalites,
Yes,
which took place on 23rd of June 2005.
my lord,
Correct.
yes,
So you were also part of it. The other man, Dhote, was also part of it.
yes,
So the question was to give both of you some incentive in the form of promotion
yes,
by bringing you in that extraordinary channel,
my lord,
which is
yes.
either unqualified or out of turn. Unqualified is out of turn.
My
Same
lord,
thing. You may call it by whatever
my
name.
lord, this thing keeps a difference on that.
We'll call it same thing. So you also got one out of turn. He also got one out of turn. But you got your promotion to head constable in the out of turn category.
Yes,
But he was promoted earlier to head constable in his normal channel.
yes,
So therefore, his out of turn was implemented for the next level. What is wrong in it?
my lord, that is what I
If I
was,
have understood the case, that is the fact.
that is the respondent's case, my lord.
I
That
think you
is,
have a
that
good
is what the
case.
respondents are trying to impress. What I'm trying to impress, my lord, is that when we both were in the same post, and for me, the post on the date of incident is being taken to deny me the unqualified promotion, giving me a promotion to which I had already qualified.
Hmm.
Had this 1910-2005 perhaps come 2 days later, I would also be in the rank of a head constable and I would have become an SI per their logic also. I mean, look, the unqualified, if Lordship will kindly have the rule
So are
regarding
you
the,
saying that on 21/10/2005, you would have been in any case promoted
to
as-
the rank of head constable, in any case I would be there. So it is not an unqualified promotion for me. It is a qualified promotion for me. They are simply giving it out of turn. If it is to be an unqualified promotion, if I am to be awarded with an unqualified promotion, it has to be to a rank to which I am not qualified on the date I am being considered. That is what the rule says, my lord. If Lordship will have the rules for a moment, my lord.
Yes,
CRPF.
Have you submitted any representation?
Yes, my lord. A legal notice was given to some sort, my lord. They had replied to it. They are trying before this court, my lord.
What is the reply?
My lord, the reply is that on the date of incident, you were a constable, you have got an out of turn promotion.
Hmm.
On the date of promotion, Dhote was a head constable, therefore we made him an SI.
So in other words, the benefit you got is
Something which would have come routinely,
quantitatively less than what Dhote got.
and what would have come routinely to me, maybe in a month or two, or maybe in a day or two.
Maybe, but it has, these are all conjectures and surmises.
No,
In fact-
when it came to,
Just a minute, the fact of the matter is that you got a promotion at least 24 hours before to a post which you would not have got on that day.
on
That
that,
you have-
yes, that is not denied. That is not, that I cannot.
But you are not satisfied with
I
it.
have got it out of turn, but I have not got it under the, today to an unqualified post. That is the entire case of the petitioner. my lord.
So you give up your out of turn, go back to constable first, then they will consider.
But that was already considered, my lord.
Are you challenging your promotion out of turn to head constable 1910/2005?
Or I say the proper rank was not given to me. Once a promotion was given to me, I had no option but
You
to
are
stand
still
in
head
those shoes.
constable.
I'm still a head constable. The other person has now taken promotion to the rank of inspector. Perhaps the deputy commander, if I'm not wrong, it's an assistant commandant now. He's now. Because at that point of time, had that been given to me, a person, I would have been on the same footing with that person. Now, therefore, I left behind, I'm still with my batchmates, I'm still where I am.
So you
At
are
the
still
very-
where you should be. Why don't you look at it that way? Other
Lordship, my
person has flown off. That's
Lordship, my
good
like-
luck.
My lord,
See, many people fly off the roof. That happens everywhere. But you are where you should be. Or you ought to have been.
we took the run together. I would like to fly together.
Huh?
We took the run together. The petitioner would like to fly together with a person. My lord, this was but why the petitioner, my lord, had me remove this petition was, it was an incident where they were attacked by around 80 Naxals. It was only the two of them who lay down on a paddy field for around 48 hours before help could reach. In Bihar, it was a Naxal attack at that point of time. There was a bank robbery. And these two are the only persons who laid down on the paddy field for around 48 hours. That is also on record. Where, my lord, the urea from the entire field had even gone into their clothes and they were in a very bad medical shape. Everything said and done, the two persons standing together, one gets to become something very high up. I laying down on
But
the
he's senior to you also.
he was a senior by a year, my lord.
Whatever.
By a year, he's senior.
You're senior to you.
Even if I was given the promotion along with him, I would still remain his junior. Because the enlistment year is what counts for seniority at that point of time. So
No, Mr. Majumdar, you see, leaving aside everything.
if Lordship would only have rule
I
17,
will have a look at the rule 17. But you see, you were promoted as HC on 1910/2005.
my lord,
That promotion you have accepted.
yes, I have accepted.
Then when should have been your next promotion? Are you saying that your promotion on 1910/2005 ought to have been to the rank of sub-inspector and not head constable?
If I'm considered under the 10% unqualified quota, yes.
Then
If
where is the order promoting you to post of head constable?
This was the order, my lord, I had just read out, that I have been given the rank of head constable. Page 25, my lord.
This is the order of 11 April 2006.
Yes, my lord, with effect from, my lord, they've given the effect from 1910-2005.
Correct.
Last but 3 lines,
Yes. So you were promoted as HC with effect from 1910-2005.
2005.
So before that, you are saying you are already an HC.
I'm qualified to be an head constable, and since it is not denied that I was on the approved A list, just if I show the standing orders, my lord, I could have been brought onto that list only when against an existing vacancy to which I was supposed to be released. That release order at the directorate level takes time.
But
For all
that is a, see, it's like saying if the DPC has considered a candidate, that means he is promoted.
No, my lord. Here the situation is such that I can only come on the list if there is a vacancy. A
Okay,
second
then
person
let's
cannot
take
come.
it that there were 4 vacancies in the rank of, say, executive engineer.
My lord,
DPC considers and recommends 4 persons.
4 persons.
That means he is promoted on that day.
Per the standing orders, my lord, that is how it is, my lord. That per the standing orders, that is how they deal with it, because in the force, my lord, the date of promotion or the ranking of even 1 day leads to, my lord, being a senior who can command on anything. So even that one particular
Which rule you want to show?
my lord, rule 70 if lordship has
70.
70, my lord.
Yes. Yes, please.
The commandant may, on the recommendation of a company commander, promote to the rank of Lance Nayak and Nayak. Lance Nayak and Nayak are no longer there in the force. So the promotion now comes to the head constable. Respectively, a constable, Lance Nayak or a Nayak, who, although not qualified for promotion, is considered in all respects capable of acting as an under officer, provided the number of unqualified so-and-so may not at any time exceed the 10% sanctioned number of posts in each rank. So it is very different. The unqualified quota is a very different thing from giving an out-of-turn promotion. The commandant does not give promotion to a person who is senior most and is capable. No, he can pick up any person who is unqualified for the post, but is required to hold the post, but can hold the post. So that is the 10% unqualified quota. It is not simply an out-of-turn promotion.
And what is the list you said? You are in the list.
AGD list that lordship will find in my writ petition. It starts at page 16, my lord.
Yes.
Lordship would have 16, page 16, down below clause B. Brief details and eligibility for the promotional courses from constable to head constable.
Page 16 of your writ petition.
Writ petition, my lord.
That is annexure A.
My lord. That is the procedure for promotion of non-gazetted officers, general duty executive personnel to various ranks from constables to inspectors. Now, my lord, B, clause B.
Yes.
From brief details and eligibility for the promotional courses from constable to head constable. He must have completed 7 years, must have qualified JCC. Constables will be detailed for SCC strictly in accordance with their seniority. SCC 6 weeks, so and so, my lord, till the next page, page 17, clause number 5. This is what the qualifications required are. Thereafter, lordship will have.
So those who fulfill this qualification
Are qualified.
their names are included in the.
No.
Then
Those, everybody can qualify. Now, whose name will be included? Lordship will find it page 20. Page 20, down below clause I. Drawal of approved list. Approved list AGD promotion from constable to head constable. Constables who have completed minimum 8 years of service as constable and have successfully completed JCC qualified in section commander course and found fit shall be brought on approved AGD drawn by the selection board, subject to availability of vacancies and their particulars be forwarded to Directorate General, duly consolidated at range sector offices for releasing them on promotion centrally according to the force level inter se seniority. Once the person is put on the AGD list, it simply goes to the directorate. According to seniority, the promotions are thereafter released because it is directly related to the vacancies. The first line I'll read again of that page, shall be brought on approved AGD drawn by selection board subject to availability of vacancies. Now that we both were on that special approved list is not denied anywhere. That is an admitted position. So the forwarding to the
Both of you were in the approved.
yes, and therefore both our names had already been forwarded to the directorate. Dhote being senior to me on that AGD list, his promotion came to be released in May, immediately after the incident. That lordship will find in the list of date that I have given. Incident took place on 23/6/05. His release came on 23/8/05.
But he was also made a head constable.
Because he was already there on the AGD list. So he became his promotion was released. My promotion was not released. They were going through the seniority list. Now, when the time comes to give the unqualified promotion, his case for unqualified promotion, we are from the same battalion, both recommended together for SI at the same time. For me, it is constable on the date of promotion, therefore not SI, you become a GD. For him, on the date of consideration, you are a head constable, therefore SI. Now, if the consideration for both of us had remained constable GD on the date of promotion, or on the date of incident, therefore both become head constable, I would not have the heartburn. If the consideration was that on the date of promotions, you take it, both of us, because you were a constable, then also, my lord, to some extent, if his head constable was not on the just being released prior to me, there would be no heartburn. But the date of consideration, if kept constant, he becomes an SI. Can I be kept at at the rank of head constable, which would be my routine promotion? Unqualified, I have shown, my lord, unqualified is something to which one is not entitled to hold the post. He's not on the GD list. Because if lordship will have just 2 more pages behind, at page 17, I'm sorry, page 21, just the next paragraph, approved list B, promotion from head constable to SI. Here only those persons will come who were qualified for the post of SI. Dhote got this promotion because he was not qualified for the post of SI. He had done none of the courses. In a period of 3 months, he could not.
So you are saying you are in any case qualified for head constable.
Head constable, and therefore, if it is a promotion to the unqualified, under the unqualified 10% quota, it had to be to a post for which I was not qualified, which remains the post of SI, which has been given.
Right. What is their reply to your legal notice?
Their reply, my lord, will find at page 38 is the typed copy, my lord. 37 is the original, 38 is the typed copy. The case has been examined, para 2 I'm reading, my lord. Very para 2. The case has been examined and it is intimated that your client so-and-so had qualified requisite course of SCC serial number 26 and brought on approved list AGD 8/04 prior to the date of encounter, that is 23/6/05, and not physically promoted to the rank of head constable GD as on the date of encounter. He was a constable GD on the date of encounter and given out of turn promotion with effect from 19/10/05 under the 10% unqualified quota. It is pertinent to mention that personnel who underwent SCC serial number 26 together with client of the advocate has been promoted as head constable GD in normal course only on 25/1/06, giving seniority from the same date, that is 25/1/06, whereas the client of the advocate has been given promotion with effect from 19/10/05, giving seniority from the same date. Therefore, he has become senior to thousands of constables of his batch. As such, he has been benefited from out of turn promotion. Your contention that RM Dhote and your client were holding the equal post of constable on the date of encounter is correct. But RM Dhote was promoted normal course as head constable GD with effect from 23/05 before the out of turn promotion was issued on 19/10/05. On the date of issue of the out of turn promotion, Dhote was holding the rank of head constable GD, whereas your client was holding the rank of constable GD. Therefore, constable GD RM Dhote was granted out of turn promotion under 10% unqualified quota to the rank of SIGD instead of head constable GD, which is in order. Since the department has adopted correct procedure, no action on the instant legal. So my stand that it is to a unqualified post was not answered. What they tried to turn it
Yes,
into was an
yes,
out of turn.
Mr. Dev Chaudhary, it appears that the claim for unqualified promotion has been converted into a claim of seniority.
Subject to what my lord holds. In any case, lordship has seen that Dhote was senior to the petitioner by around a year. And he got his promotion as a head constable in the normal course. Naturally, when the next promotional post will be announced or is declared, it will be on that particular occasion that who is where that will be considered. Admittedly, lordship, he was junior in the list of the constables by a year or so. And in normal course also, Dhote had to be promoted prior to him if they also had a similar qualification like my learned friend submits. Even if they had a similar qualification, Dhote would have been promoted before.
He is not after Dhote.
Yes. And my case before your lordship will be, it will be only on the date when the next promotional posts are announced. The 10%.
No, Mr. Dev Chaudhary, please try to understand
Yes.
this. The facts, as I could gather from what you have said, you are free to controvert it.
Yes.
Both these persons, the petitioner was obviously junior to Dhote, but he is probably referring to Dhote to bolster his case.
Yes.
He doesn't have any grievance against
No,
Dhote.
otherwise he would have been made a
Yeah.
party.
So what he is saying is that both of them were part of an incident which took place on 23rd of June 2005, which had merited unqualified promotions to both of them.
To what?
Now, in his case, the authorities have taken a stand that they've given an unqualified promotion to him. But actually, this is a promotion which he would have got in any case. Even according to the authorities,
Yes.
if not on 19/10/2005, he would have got it on 25/1/2006.
Yes.
Yes, lordship.
So the promotion to head constable is not unqualified. He is qualified for that post and he would have got it.
Lordship.
As per the stand in 19 June 2007, it appears that they are mixing up seniority with unqualified promotion.
Apparently. Lordship.
So seniority is one thing and unqualified promotion is another thing.
I'm with you, lordship.
So his promotion to head constable would not come under the category of unqualified promotion. That is his argument. So even if the authority's stand is accepted,
Lordship.
that his seniority and promotion with effect in the post of head constable ought to be counted from 25/1/2006. Even then,
Lordship.
he has not been given the unqualified promotion. Correct. So that has been dressed up. The normal promotion has been dressed up as an unqualified promotion by merely preponing the
Promotion.
Yes,
Promotion.
notification of promotion by 2-3 months. So that is a eyewash according to him. That is not in consonance with the purport and intent of the rules. That's his case, if I've understood. Is that your case?
Exactly, madam. That is what it is.
Though I would be, so-
Which of the, yes, live streaming বন্ধ করো। সাহাবে কিবা এটা copy and it's Deputy Solicitor General of India appearing for the respondents, full stop. In the instant writ petition, the core controversy pertains to promotion given to the writ petitioner. The purported promotion given to the writ petitioner under the category of within quotes unqualified promotion, comma. According to the writ petitioner, although the colleague of the petitioner, namely Sri R.M. Dhote, who was entitled to similar, who was a part of the same incident and was entitled to similar benefit for the act of gallantry, was promoted to the rank of sub-inspector under the unqualified and under the 10% unqualified quota, in case of the writ petitioner, the authorities have merely preponed his promotion to the rank of head constable by about 3 months and dressed up the same as promotion against 10% unqualified quota, although the petitioner was at that point of time already in the approved A/GD list of constable for being promoted to the rank of head constable in usual course, full stop. The facts of the case, in a nutshell, are that an incident took place, are that the writ petitioner herein had joined the Central Reserve Police Force, bracket CRPF, bracket close, as constable, bracket general duty. That was the next type of bracket, CT/GD, bracket close, in the year 1989. Thereafter, he was subjected to the usual in-service training, which he qualified in the year 2004, and therefore was eligible for being promoted to the post of head constable general duty, bracket HC/GD. In view of his above qualification, the petitioner was also brought in the approved list capital A/GD-8/2004, full stop. He was thereafter granted financial upgradation with effect from 18/08/2004, full stop. Eventually, the promotion of the petitioner to the rank of HC/GD was notified on 11/4/2006 by giving effect to the same from 19/10/2005, full stop. The aforesaid promotion of the petitioner to the rank of HC/GD was projected as one given out of turn, that is out of turn within course, that is under the 10% unqualified quota, full stop. According to the petitioner, Sri R.M. Dhote, who had joined the CRPF as CT/GD in the year 1988 and hence was senior to the petitioner in service, was one of the 2 constables along with the petitioner who was on duty on 23/6/2005 when an incident of encounter with the terrorists took place, full stop. Due to the act of gallantry shown by the petitioner as well as Sri R.M. Dhote, both of whom were serving as constables on the date of the incident, the authorities had recommended promoting these 2 constables against the 10% unqualified quota, full stop. Sri R.M. Dhote, being senior to the petitioner in the rank of constable, was promoted to the rank of head constable with effect from 23/8/2005, full stop. Thereafter, he was promoted to the rank of sub-inspector, bracket SI, bracket close, against the 10% unqualified quota. However, the claim of the petitioner for promotion against 10% unqualified quota was turned down by projecting his promotion to the rank of HC as one coming within the said category, full stop. Aggrieved by the aforesaid decision of the authorities, the petitioner had submitted a legal notice addressed to the additional DIG bracket PERS Roman 3 bracket close on 21/3/2007 full stop. However, by the communication dated 19/6/2007, the grievance raised by the petitioner was negated by the authorities by contending that while the petitioner would have been promoted as HC/GD in normal course only on 25/01/2006, his by preponing his promotion to the said rank with effect from 19/10/2005, thus giving him seniority over other constables. The benefit intended to be given to the petitioner was extended to him, full stop. By assailing the decision of the authorities, next para, as well as the communication dated 19/7/2007, Mr. Majumdar submits that the writ petitioner in any case was in the approved list of HCGD and would have been and his promotion would have must be treated to have been a foregone conclusion as on the date of the incident. That is date of the incident, is it, Mr. Majumdar? As on the date of the incident, that is 23/6/2005. Therefore, now 2005. Thereafter, no promotion has been given to the petitioner. Therefore, it is a clear case where the authorities have extended the benefit of unqualified promotion to his colleagues, namely Sri R.M. Dhote, while denying such benefit to the petitioner, although both of them were entitled, both of them being part of the same incident of gallantry, were entitled to similar benefits. Full stop. In support of his above argument, Mr. Majumdar has placed reliance on the provisions of Rule 70 of the Central Reserve Police Force Rules, 1955, to contend that an unqualified promotion is given to those candidates to the rank to which otherwise they were not qualified to be promoted. Full stop. Since the writ petitioner was not only qualified to be promoted to the rank of HC/GD, and his name was already included in the approved A list, there has been no promotion given to the petitioner against the 10% unqualified quota, and therefore submits Mr. Majumdar, this is a clear case of discrimination shown by the authorities towards the writ petitioners. Full stop. Mr. R.K. Dev Chaudhary, learned DSGI, on the other hand, has argued that from the communication dated 19/6/2007, it is apparent that the date of promotion of the petitioner to the rank of HCGD has been preponed to 19/10/2005 instead of 25/1/2006. Full stop. Mr. Dev Chaudhary has, however, submitted in his usual fairness that merely by giving accelerated seniority to the petitioner in the rank of HCGD, it cannot be said that he has been given the benefit of promotion under the within course 10% unqualified quota. Full stop. I have considered the submissions made at the bar, gone through the materials available on record, and also carefully examined the provisions of the rules. Full stop. A perusal of the procedure for promotion of NGO (GD) bracket close, executive personnel, bracket male/female, bracket close, to various ranks from constable to inspector under standing order number 6/1999, page 16 of has been annexed to the writ petition as annexure 1. A perusal of the standing order clearly reflects that approved list A/GD is meant for promotion of constables who have completed minimum 8 years of service as constable and have successfully completed JCC, all capital, qualified in section commander course, bracket SCC, bracket close, and are found to be fit, who shall alone be brought in the aforesaid approved list drawn by selection board, subject to availability of vacancy. Full stop. The particulars of such constables were required to be forwarded to the Directorate General Personnel Roman 2 branch, duly consolidated at range/sectors offices for releasing them on promotion centrally according to the force level inter-se seniority. Full stop. From the above, it is clear that once the name of a constable finds place in the approved A/GD list on meeting the eligibility norms, the further action that would be required to be undertaken is in the matter is to release the concerned candidate on promotion according to the inter-se seniority of the constable. Full stop. In other words, it is apparent that, all constables whose names are included in the approved A/GD list are already shortlisted for promotion to the rank of HC/GD, and the only question that would remain to be determined is the date of release of these constables on promotion, depending on their inter-se seniority. Full stop. If that be so, it cannot be said that the writ petitioner herein, who was already included in the approved A/GD list prior to the date of the incident on 23/6/2005, was granted an out of turn, within quotes, out of turn, or 10% or promotion against, within quotes, 10% unqualified quota, as has been projected by the respondents. Full stop. What has merely happened is that the petitioner, the respondents appear to have released the petitioner on a prior date by ignoring the inter-se seniority of the constable. Full stop. However, even if that position is accepted, the same cannot, in the opinion of this court, be termed as an out-of-turn promotion or promotion against 10% unqualified quota. Full stop. Merely because a constable is granted accelerated seniority in the rank of HC/GD, the same, in the opinion of this court, cannot be equated with an out-of-turn promotion. Full stop. Situated thus, this court is of the unhesitant opinion that despite having shortlisted the petitioner for promotion on out-of-turn basis against 10% unqualified quota, along with the other constable, namely, what is his name?
RM Dhoti.
RM Dhote. no such promotion was actually given to the petitioner. First of all. On the contrary, his promotion to the rank of HCGD, which would have come to him in normal course, but after a delay of about 3 months, was dressed up to look as though it was a promotion granted out of turn, merely by tinkering with his inter-se seniority amongst the ranks. Full stop. Such a recourse, in the opinion, no, full stop. The aforesaid provision also stands clearly established from the reply dated 19/6/2007 furnished by the ADIG bracket PERS Roman 3 bracket close in response to the legal notice dated 21/3/2007 served by the petitioner. First up. Having gone through the materials on record and in view of the discussions made herein above, this court is of the opinion that the respondents have deprived the petitioner of the benefit of out-of-turn promotion, oblique promotion against 10% unqualified quota, comma, for the act of gallantry shown by him, although similar benefit was given to the other person, namely Sri R.M. Dhote. Full stop. This writ petition therefore succeeds and is hereby allowed. The communication dated 19/6/2007 stands set aside. The matter is remanded back to the respondents to consider the case afresh for promotion, for his promotion from the rank of HC/GD to a higher rank against 10% unqualified quota. Full stop. In doing so, it will be open for the respondents to treat the promotion of the petitioner to the rank of HCGD with effect from 25/1/2006, if so advised. In other words, no accelerated seniority need be given to the petitioner insofar as his promotion to the rank of HCGD is concerned. However, the case of the petitioner for promotion against 10% unqualified quota shall be considered and the same be given effect from any date after will be given effect from
If it could be given from the date the other person was given or from the date.
Let it be open for the authority.
given effect
Otherwise,
from a date on which his juniors were promoted to the rank of SI. Juniors were promoted to the rank of SI.
his colleagues or juniors may not have reached the rank of SI as of date, my lord. That because if he's there,
No, then you write, it'll be open for the respondents to give effect to such promotion to the rank of SI as may be deemed.
from the date he held the post of, he was given the promotion to the rank of head constable, my lord.
Yes, you will be head constable with effect from 25/1/2006. You can't get both.
Yes,
Your seniority will be, your promotion should be
what I was
treated as
saying is,
with effect, promotion of the petitioner to the rank of HCGD shall now be treated to be with effect from 25/1/2006 as per projection made in communication dated 19/6/2007. First up. On such basis, the respondents shall now consider the case of the petitioner for promotion to the next rank of SI under the within course 10% unqualified quota bracket unquote. Full stop. His promotion to the aforesaid post of SI shall be given effect to from a date as the authorities deem fit and proper. However, the exercise as directed by this order be carried out and completed within a period of 3 months from the date of receipt of a certified copy of this order. Read petition shall disposed of. Please. Anything else?
my lord, consequentially, to his sub-inspector, whatever they give him consequential benefits.
That will automatically, there is no need to say that. Let him come to you again for that.
None.
He has a case.
Huh?
He has another case.
Yes, yes.
Only explain.
I think we're getting adjourned votes.
May it please your lordship. I have filed this stay vacating petition, my lord, including the order dated 29/3/2023, by which my appointment, my selection for the post of Gambura has been interfered with. My lord, the entire case projected by the petitioner, my lord, is that she was within the age limit, but she had submitted a wrong birth certificate. Therefore, she was not called for the interview. Thereafter, she submitted her correct birth certificate as per the convention of the petitioner, and she falls within the age limits.
Where is the
If-
order? Where is the?
My lord, order is in my IA, my lord, from page 14, my lord. Starts at page 15, my lord.
Page 14.
Page 14, starts at page 15, my lord. From para 2, it is submitted by the learned counsel, last line.
Mhm.
Learned counsel for the petitioner that she satisfies all the criteria. However, by oversight, she had submitted wrong documents in support of her age, which had perhaps led to disqualification of her candidature. And therefore, she was not called for the interview. However, prior to the interview, she submitted the relevant particulars in support of her age, which a birth certificate is issued by the competent authority under the Directorate of Health Services and she H the writ petition, but the petitioner was not shortlisted for the interview. It is submitted that in spite of representations being made, she was eligible for appearing in the interview conducted by the for selection of Gambura by virtue of the birth certificate dated 16/10/22 submitted by her. The authorities concerned did not call her for the interview. She has subsequently been informed that respondent number 7 has been selected as Gambura for village so and so. Being aggrieved, petition has been filed at so and so. My lord, para 7, prima facie, it appears to the court that the petitioner was eligible to be called for interview on the basis of the birth certificate, which was submitted subsequently.
Petition. Who is the petitioner?
Lordship,
You argue.
Lordship, it is an admitted fact, Lordship,
Hmm.
that after getting my corrected birth certificate,
Mm.
I have submitted the same before the concerned authorities.
What was the last date of submission of documents and
Last date of submission of forms was 21/9/2022, Lordship.
when did you submit the corrected birth
Uh,
certificate?
Lordship, I have submitted on
Page 46.
page 46, Lordship.
Mm.
Yes.
'26 to 2023, Lordship.
26 to 2023.
Lordship.
So now you want that whole selection should be scrapped. You should be interviewed and then they should
No,
proceed.
only on that particular lot, Lordship. Only on that particular lot. Apart from that lot,
Where is the advertisement?
Lordship, advertisement is at page 36 here, Lordship.
Mm.
Annexure G, Lordship.
Last date of submission of documents.
Last date, page 39, Lordship. Applicants should submit their application forms from 7/9/2022 to 21/9/2022, Lordship.
So what is the relief you are seeking here?
Lordship, I have submitted my corrected date of birth certificate after obtaining from the concerned authority after that specified period, number 1. Apart from that, Lordship, there are other allegations which I have submitted in para 11 of this writ petition, Lordship. That the interview was not conducted as per the norms approved by the executive instructions. And number 3, your Lordship, there is an appellate provision also. If if your Lordship permits, I may approach the appellate authority also, Lordship.
Who is appearing in this case?
I am appearing, Mr. Lordship, 2, 3, 4, and 5.
All right. Take down. Heard Mr. P.K. Bordeloi.
P. Bordeloi.
P. Bordeloi, learned counsel.
My lord,
Appearing for the writ petitioner. Also heard Mr. J. Handik, learned standing counsel, Revenue Department, Assam, appearing for the respondent numbers
I am appearing 3, 4, 5, and 6. 1 and 2.
1 and 2. Mr. A. Chakravarti, learned government advocate, Assam, appearing for respondent numbers 3 to 6. And Mr. P.D. Nair, learned counsel for the respondent number 6. Full stop.
7.
Sorry, 7, full stop. The read petitioner herein had submitted her candidature for selection and appointment as Gao Pradhan in respect of which village?
11 Quarrytoll Part 2 Lot Village.
11,
Quarrytoll Part 2 Lot Village.
11 Ponital Part 2, Lord Village. Full stop.
It I know synopsis in line number 6, Lordship.
It's there in the synopsis. Gao Pradhan of 11 Ponital Part 2, Lord Village under Borbhogia Moja, Poliabor Revenue Circle in the district of Nogao. Full stop. As per the advertisement notice dated 5/9/2022, the last date for submission of applications along with supporting documents was fixed at 5 p.m. on 21/9/2022. Full stop. It transpired that as per the particulars submitted by the petitioner, as per her, along with the application, her date of birth was wrongly projected, as a result of which her candidature was not accepted. Consequently, full stop, consequently, she was not called for the interview. Full stop. Subsequently, the petitioner got her
Correct.
date of birth corrected in the relevant document and thereafter submitted the same before the authorities on 26/2/2023. However, since the last date for submission of documents stroke applications was over by then, the same was not accepted. In the meantime, the selection process was concluded, whereafter the respondent number 7 has been declared to be the selected candidate. Full stop. At this stage, the writ petitioner has approached this court by filing the instant writ petition, internally contending that the selection process stood vitiated due to the irregular manner in which the interview process was conducted. Full stop. According to the petitioner's counsel, the application submitted by the petitioner ought to be accepted and she be permitted to appear in the interview process for the purpose of selection of candidate for the post of Gao Pradhan of the 11 Quarrytoll Part 2 lot. Full stop. Mr. Bordole has further submitted that since there are several anomalies in the process leading to selection of respondent number 7, the petitioner be permitted to also prefer a statutory appeal before the concerned authorities. Full stop. The aforesaid prayer has been strongly opposed by Mr. Nair, learned counsel for the respondent number 7, by contending that no case, whatsoever has been made out by the petitioner for interference by this court. Similarly, the stand of Mr. Hendick and Mr. Chakraborty appearing for the official respondents in this case. Full stop. It is the admitted position of fact that the application found by the petitioner within the prescribed date, within the last date as prescribed by the advertisement notice was defective due to incorrect representation of date of birth, and the same was accordingly rejected by the authorities. First step. Therefore, the petitioner could not participate in the interview process. First step. Subsequently, the petitioner appears to have got a corrected document showing her correct date of birth, but the fact remains that by that time, the last date of submission of application had already expired. Full stop. Under the circumstances, the question of permitting the petitioner to participate in the interview after the date of closure of submission of application cannot arise in the eye of law. Full stop. If the application of the petitioner was not in accordance with the requirement of the advertisement, she could not have been allowed to participate in the interview. Full stop. Under the circumstances, this court is of the opinion that this writ petition would not be maintainable at the instance of the petitioner. So, in so far as the alternative prayer made by Mr. Bordole for permitting his client to file an appeal, questioning the validity of the selection process, the said prayer also cannot be accepted by this court simply on account of the fact that since the petitioner was not allowed to participate in the selection process, no locus can be identified. No locus can be recognized in favor of the petitioner to assail the selection of the respondent number 4 for appointment in the post of Gaon Pradhan. Full stop. For the reasons stated herein above, this court is of the opinion that there is no merit in this writ petition. The writ petition is accordingly dismissed. Interim order passed earlier shall stand vacated. And in view of the order dated so and so, I stand disposed of. Mr. Bordolo, you have tried, but there is absolutely no
Lordship.
merit in your case. I hope you understand. this.
Lordship.
You have done your job.
Lordship.
Now we have done our job.
Lordship.
All right, 5 minutes will come back.
Deeply.
Please, your lordship. Lordship has heard the matter. We have kept his part heard, lordship.
Yes.
Lordship. The main contention of my learned friend is that regarding that office memorandum, but this office memorandum never overrides the rule. It is only the procedural part, how to implement the promotion in case of inflicting of promotion. In the present case, the writ petitioner lordship, he was imposed the punishment of holding up to increments with cumulative effect. Because of that, till expiry of the this office memorandum says that till expiry of that penalty, his promotion should not be considered. Against that, he came. So on that lordship, I am relying on a judgment lordship. This judgment squarely covers the case of the petitioner, that is 1996 6 SCC. 1996 6 SCC, page 246. Only 4 paragraphs. Yes, 8 SCC. 8 SCC 246. Al Razaya versus
Yes, para?
3 and 4.
Yes.
May I read, lordship?
Hmm.
The petitioner was, in this case, lordship, the respondent was appointed as a junior assistant. Some departmental inquiry proceedings were initiated. He was imposed the withholding of increment, initially 1, thereafter 5. Now your lordships may come to paragraph 3. See, so and so the learned counsel for the appellant contended that the stoppage of increment is not a penalty for promotion. Under rule so and so of the AP state and subordinate service rules, if promotion is withheld as a penalty, the appellant became ineligible only for promotion. Stoppage of increment is not a penalty by way of promotion. Under the AP Civil Services Classification, Control and Appeal rules, various types of penalties have been prescribed. Penalty by way of promotion is one of the punishments imposed. In our case, lordship, withholding of increment or promotion. Therefore, the respondents cannot deny the promotion to the appellant. Though prima facie the argument is plausible, it is difficult to accept the same. Rule so and so itself indicates that promotion would be made on the basis of seniority cum fitness. The rule reaches under. So this is the rule: promotion of non-selection of category or grade withstanding anything contained in special ad hoc rules and promotions in non-selection. Then
paragraph 4, Lordship. A reading thereof clearly indicates that notwithstanding anything contained in special ad hoc rules, all promotions to non-selection category or grade cell subject to the provisions of Rule 16 may be made in accordance with seniority cum fitness unless promotion of a member has been withheld as a penalty. Though due to stoppage of increment, he is not ineligible for consideration for promotion, he is otherwise entitled to be considered in accordance with the rules, namely seniority cum fitness. However, when the seniority cum fitness is a criteria, the imposition of penalties for 1 year on 1/3/1988 and in another inquiry stoppage of increment for 5 years from 1/3/1989, that is till 28 to 1994, this entitled him to be considered. So he didn't regain fitness for consideration for promotion as he was under disability undergoing punishment. Consequently, when the promotion to the post of senior assistant in on the basis of merit and ability under special rules, fitness is one of the considerations for the purpose. Since we are undergoing punishment during the relevant period, he is not eligible for consideration from promotion. Therefore, his juniors have stolen march over the appellant as senior assistants. He cannot thereby have any grievance. However, he is entitled to be considered for promotion according to rules after 1/3/1994. The appeal is accordingly disposed of, no costs. So in this case also, Lordship, he becomes disabled because of the punishment imposed of withholding of 2 increments. So his case will be considered after expiry of that punishment.
When the punishment will expire?
My learned friend has on that day, July 24. As because 2 withholding of 2 increments. So it clarifies most probably the whole thing.
Anything else?
And regarding my learned friend has on that earlier occasion had made an argument that he is praying for that this seal cover should be opened. But in my humble submission, Lordship, if the punishment is imposed, that seal covers cannot be opened. It's newly it is to be taken into consideration when his the case for promotion comes into consideration. The seal cover cannot be opened as because he cannot be equated with the other persons who are clean. He is punished by way of a censure. The seal cover cannot be opened, Lordship. That Janaki Raman is very much clear in that point. 1991 Supreme Court. That is my humble submissions, Lordship, regarding this.
Lordship, I'll contradict this, my learned senior submission, Lordship. I have placed certain judgments, Lordship is having that bunch I have given. It's a full bench judgment and this is a subsequent judgment, Lordship. It says,
No, we first deal with the Supreme Court judgment.
no, Lordship, I have given a bunch the day before yesterday.
Judgment he relied upon first deal with this. If this covers your case, then we'll not go into any other judgment.
No, this doesn't cover my case, Lordship.
Why?
I'll show
Tell
you.
us.
I'll show. This judgment says just the executive order is a procedure that is laid down to be followed by the authorities for dealing with an issue. Now, this executive order cannot override the statutory rules framed under Article 309, Lordship. This Assam Disciplinary Service and Appeal Rules has been framed under Article 309 of the Constitution of India. And this and our Honorable Supreme Court in a full judgment has clearly said the relevant rules it is admitted were framed under the provision to Article 309 of the Constitution. They are statutory rules. Statutory rules cannot be overridden by executive orders or executive practice. This is the first case, Lordship, which dealt with this issue. An executive order cannot stand above statutory provision, and this is reaffirmed by coordinate bench of the Supreme Court, which says, Lordship,
Mr. Burman,
Lordship,
you see, the matter here, I find is a little ticklish.
Lordship.
The problem is, I'm not getting the assistance to decide this matter from the perspective of the petitioner.
Lordship,
You are stuck up with the arguments you were made the other day.
Lordship,
That is not even the point here.
Lordship.
All right. The point is, once a penalty has been imposed,
Lordship.
till the time the penalty is served out, can the officer be considered to be fit to be promoted to the next level, regardless of whatever is there in the rule?
Lordship.
Here in this case, your client has been imposed with a penalty, which is withholding of 2 increments with cumulative effect.
Lordship.
The penalty will be discharged according to them with effect from July 2024.
Lordship.
While he is serving the penalty, this is what Mr. Sharma says.
Lordship.
If the purpose of keeping it in seal cover is that if after the departmental proceeding, no penalty is imposed, then the seal cover will open and he proceeds. But if he is found guilty and a penalty is imposed,
Lordship.
then also the seal cover cannot be opened and proceeded. Then what is the point in keeping the seal cover?
Lordship.
The departmental proceeding will lead to 2 kinds of situation.
Lordship.
Either he is exonerated or a penalty is imposed.
Lordship.
It can't be that keep it in seal cover and regardless of whether he is exonerated or penalty, then open it and proceed. That can't be the law.
Lordship.
That obviously can't be the law. So if he was exonerated, it is understandable that
Lordship.
we direct that open the seal cover, give effect to it.
Lordship.
If he is imposed a penalty, the said order cannot be passed according to them.
Lordship.
If that be so, then what is the procedure ahead? Obviously, the earlier consideration according to them will fizzle out, will be gone. Then he has to be considered afresh.
Lordship.
When can he be considered afresh? Can he be considered while he is still serving the penalty? Or will he have to wait till July 2024 and then he acquires the eligibility? This judgment of Supreme Court prima facie appears to be strongly supporting that argument.
Lordship.
If you do not meet this,
Lordship.
and go on harping, executive instruction cannot whittle down. These are all very elementary things.
Lordship.
There is no point repeating it again and again.
Lordship.
The point here is something else.
Lordship.
Yes, address the court on that.
Lordship, I'll come to the rule which has implied, which I was imposed with a penalty, Lordship. It says withholding of increments or promotion, or it says or promotion. That means if I support my learned senior submission, then I'll be imposed with 2 punishment, Lordship.
No, that's absolutely incorrect. You are not understanding. There could be a penalty that his promotion is withheld for all times to come.
Lordship.
That is another matter.
Lordship.
Or his promotion is withheld for 3 years, 5 years, 7 years,
Lordship.
till retirement. That is a punishment. That is one matter. If that happens, no promotion.
Lordship.
Or no promotion till such time the penalty is discharged,
Lordship.
unless it is set aside by the court. But if the penalty is something else, any other penalty, the question is, can the seal cover be opened even if there is a penalty where he is to serve a penalty and he's been found guilty of misconduct? A person who is found guilty of misconduct and has been imposed with a penalty, can he be promoted on the basis of a consideration kept in a seal cover, or can he be now, even now, today, can the court direct that you consider him for promotion and let him simultaneously serve the penalty? If you want to suggest that, you have to establish that case.
Lordship.
This is a law point.
Lordship.
This law point is not connected with anything you have argued the other day. Today, they have come up with something which the court will have to deal with.
Lordship.
And we can't say that executive instruction cannot whittle down, so that cannot be argued. That argument will not be accepted. I'm making it very clear to you. You have to address the court and throw light on this aspect, that no, I can simultaneously serve the penalty and be promoted.
Lordship.
If that decision is there, authority is there, you produce it, we'll consider, rely on that. If
The
you find
Lordship
it
will
can
grant
be-
me some time. I'll satisfy this
So
court.
that is okay,
Lordship.
but you have to change your track.
Lordship.
You are stuck up in the same track.
Lordship. Lordship.
That will be very easy for the court to
Lordship.
reject.
I
straight
understand.
away.
Lordship.
It can't be done.
I understand.
That is the fundamental issue here. This issue will be coming again and again in other cases. Either some judgments must be there deciding this aspect of law, or it has to be decided by the court for the first time. Which of the two?
Lordship, it has to be decided. It has to be
It has to be
decided.
decided.
Yes, has to be.
No decided case.
No, Lordship, may grant me some time, Lordship. I'll place.
You are appearing in this case. You are waiting in the fringes.
Only no.
You are waiting in the
Only thing is, Lordship,
wings.
in this particular case, though I have argued the case earlier occasion, I have allowed him to argue the case is on his capacity. That is why, Lordship. In this particular case, main fact of the case is, Lordship, we have already challenged the punishment imposed on us. I have already shown how punishment has been imposed. Punishment has been imposed with a finding, clear finding of the inquiry officer that the allegation against me has not been proved, not established. Thereafter, Lordship, they imposed the minor punishment, that is withholding up to increment with cumulative effect. So this punishment, I have already challenged the appellate order. Before, after imposing the penalty, I have filed appeal before the appellate authority. Appellate authority has also confirmed this punishment, though there is no proof. Thereafter, I have approached this court by filing a writ petition that is pending. That writ petition, Lordship, will hear the matter analogously. This writ petition, application number 885 of 2023, where we have challenged the punishment imposed on us.
Okay, that is another writ petition.
That is, Lordship. That is application number 885 of 2023.
Oh, so now this will again, then the matter will have to be again reheard.
Lordship, next week, Lordship will take this matter.
Oh, next week suits you, but it may not suit us. Earlier, these two cases were heard on the
Lordship,
ground that only.
In
promotion-
this case, particular case also, Lordship, we have annexed the punishment imposed on us, how punishment has been imposed. And this court has already
No,
primarily.
no, Mr. Goswami, so let's have clarity on what we are doing.
Lordship, I have heard.
Please listen. There is no harm in listening and understanding. You have to listen to the court, we have to hear you, then only we'll understand. These matters have been heard on last 2-3 occasions on an understanding that the only issue here is, can his promotion be withheld?
Yes.
That was the only issue, correct? When his promotion was kept in the seal cover, the first writ petition was filed, seeking a direction that it should be opened and given effect to. During that time, they came up with a notification of 87, which says when there is either withholding of increment or stoppage of promotion, in both cases, promotion has to be stopped. That is the notification. So you have challenged that also, correct? Now, second writ petition came to be filed on that ground.
Under this.
So the only issue involved in these matters whether his promotion can be deferred or not.
Lordship.
And on those dates also, everybody knew that challenge to the order of penalty is pending in another writ petition, which is pending before this court. There was no request to club. So when the matter is heard, it was fixed for Mr. Sharma's response.
Personal-
He has come up with an argument that till he discharges his penalty, his case cannot be considered for promotion,
Lordship,
regardless of anything. But the matter would have been different if he was exonerated. Then court can direct open the seal cover and proceed. But now that he has been found guilty of misconduct and a minor penalty has been imposed, till the penalty is discharged, question of considering him for promotion doesn't arise.
as per judgment.
And that argument
Is supported by
is
judgment.
drawing strength from this. So that is the issue here.
As per my knowledge, Lordship. As per my knowledge, Lordship, the imposed two increment has been cut off.
No, before that, if you agree with that argument, we'll close the matter saying that you consider him after July 24. If you do not agree, then you have to formulate your argument.
That is why Lordship may fix this for next week. We'll reply to the arguments which has been placed today, Lordship, regarding the judgment placed by the Supreme Court judgment, wherein it is stated that if punishment is not completed, then there is no question of promotion, there is no question of giving promotion. And in this particular case, as per my knowledge, as per my information, already punishment has been, they have imposed and they have deducted the increment also. They have deducted the increment.
So punishment has already been served.
Already been served. Already been served.
No, but knowledge will not do, then you have to bring in affidavits and then.
No, we
They have
have
not served.
brought on record that's payslip. That payslip where they have deducted the two increments.
Where
We have
is it?
brought on record.
Where is it? Let us see.
Lordship will find.
Hmm.
137.
137, page 137,
Page
37, annex 25. Lordship, order of imposing penalty, page 72, dated
Page 72.
18 April 2022. Lordship. Page 72.
Yes, yes.
Page 72 is the order dated 18/4/2022, where penalty of page 72, Lordship. Therefore, Governor of Assam is pleased to impose penalty of withholding of 2 increments with cumulative effect under Rule 7(2) of Assam Service Discipline and Appeal Rules 1964 against Rashid Acharjee, Assistant Engineer, Silchar Water Resource Department, then Assistant Engineer, Office of the Chief Engineer, Quality Control, Water Resource Department. Lordship got it. This order has been passed on 18 April 2022.
How it can be, Lordship? The penalty, oh, sorry, let my line, I'm extremely sorry, Lordship.
18 April 2022. Thereafter, Lordship, the payslip has been issued by the AG office, page 137.
Yes.
Lordship will find that is the order dated 12/5/2022. Order of imposing penalty is 18 April 2022. Thereafter, Lordship, the 2 increments has been deducted.
So when did he get the increments? Can you give the dates? First
That
increment,
clarification, Lordship, that is why that clarification, how they have deducted the 2 increments, I have to take the instruction. Two increment has been deducted after imposing penalty. They are saying that it will over on July 2024. But as per payslip, 2 increment has already been deducted. That is why we have enclosed the page 137, that 2 increment has already been deducted.
have you challenged this order 12/5/2022?
We have not challenged because there is no question of challenging that penalty has been imposed. That has been, Lordship, we have sought the penalty, though we have challenged the punishment.
So what remains in that writ petition then?
That writ petition, Lordship, before that, they have deducted.
No, you are not understanding. That writ petition is infructuous then.
No. We have given order of punishment on 18 April 2022. By this time, we have filed appeal before the appellate authority. Before appeal has been disposed of, the AG has deducted the 2 increments. Before disposal of the appeal was disposed of subsequently. Appellate authority has confirmed the punishment imposed by the disciplinary authority. Thereafter, I have approached this honorable court. So before appeal was disposed of, reduction has been made.
Lordship, well, the penalty was imposed in the month of April 2022. In average, according to my learned friend, the average July, this increment is added. So how in the year 2022, the increment of 19 and 20 can be deducted? And
How we have
according
done,
to the affidavit now, the Lordship, it goes in some other way. The affidavit filed by the Water Resource Department, they have stated that it's a manipulated document in their affidavit.
This
In
is-
their affidavit, Lordship.
This is payslip.
In their affidavit, they have
So
said in
which
paragraph
what-
9.
Before 2 years, he got 2 increments.
Deduction of 2 increments.
Peculiar
There is no question of
situation
2 years.
arisen now.
Lordship, can see page 72 again. Withholding of 2 increments, cumulative effect.
That's
Withholding
correct.
of 2 increments,
Withholding.
or not 2 years. Not for 2 years. They are saying,
Oh, you understand, no? A government employee gets increments every year.
every year.
So what he's saying is the penalty was imposed in April 24. Correct.
22.
That's right, 22. So in 23, there was 1 increment due which has been withheld. Other increment will be due only on July 2024.
According to them.
Yes.
But AG is doing all these things. How AG has done, I do not know.
Janu, after 1 month.
So, Mr. Goswami, perhaps you need to apply your mind on what exactly is your strategy.
Next week, Lordship.
Because if you go here and there, it will delay the matter further. AG is not a party here.
AG is party.
AG is a party.
It is
Yes.
party.
How many increments have been did? Then what have you been doing so long? You are just sitting here.
From the Facebook that no increment was deducted.
Huh?
On the Facebook that 137. According to my learned friend, Lordship, in page 137. 137, according to him, in 1/1/2019, his pay was 43,050. In 1/7/2019, according to them, in July, there should be an increment. According to them, it should have been increased, but it is again 43,050. In 2020, in August, again it is 43,050. So according to them, two increments have already been deducted by DSG. Whether it is, but how it can be deducted when the punishment is imposed in 2022? That is why the water resources department,
Clarify, Lordship, how they have deducted.
that is the, whether is there any
Mr.
punishment earlier, Lordship, I do not know regarding.
Mr. N. Burman appearing for the petitioner in these writ petitions. Mr. H. Sharma,
1920
additional junior government advocate,
No, 19 of
made his submissions to the by contending that since the penalty of withholding of 2 increments with cumulative effect has been imposed upon the petitioner by the order of penalty dated 18/4/2022. Until such time, the penalty is fully served by the petitioner. His case cannot be considered for promotion. Therefore, the question of issuing a direction to open the seal cover consideration of the petitioner's case would also not arise in the facts of the case. In support of his above argument, Mr. Sharma has relied upon a decision of the Supreme Court rendered in the case of L. Rajaiah, RAJAIAH versus Inspector General of Registration and Stamps, Hyderabad and others, reported in bracket 1996 bracket close 8 SCC 246. Mr. Goswami, on the other hand, submits that the 2 increments have already been deducted from the has already been deducted in respect of the petitioner, which fact is established from the pay slip dated 12/6/2022, issued by the Office of the Accountant General bracket ANE bracket close Assam. The aforesaid position has been factually disputed by the Respondents' Council. Mr. R. Dharan, learned counsel appearing for the AGANE Assam, prays for a week's time to obtain clarificatory instruction in the matter. First up, Mr. Anand Das, SC Water Resources Department, Assam is present and also seeks some time to clarify as to whether the penalty has already been discharged in respect of the petitioner. Mr. KK Day, learned counsel for the private respondents seeking vacation of 6 to 8 is also present. In view of the requests made in the bar, these matters are directed to be listed again on 10th of August or 3rd of August, 2023 as fixed parter matters so as to enable the petitioner's counsel to obtain instruction. So as to enable the learned counsel for the respective parties to obtain instruction.
Lordship, may kindly take IA number 1961. It is the vacation of the order passed by your Lordship on 21/4/23, Lordship. Because of that order, Lordship, we are not able to give promotion, Lordship.
Who has filed this IA?
State of Water Resource Department, Lordship.
Mr. Arendras, learned counsel for the Applicant also heard Mr. S.K. Goswami, Learned Counsel appearing for the OP petitioner. By filing this IA, the
Page 10 to 13, Lordship.
state of Assam, along with the chief engineer of Water Resources Department and the executive engineer, Water Resources Department, Silchar, have acknowledged this court with a prayer to vacate public modify the interim order dated 21/4/2023 passed by this court in WPC number 2125 public 2023, whereby this court has restrained the respondents from promoting the departmental candidates to the rank of
Assistant
assistant
Executive Engineer.
executive engineer on the basis of recommendation of the DPC. One post. Mr. Das submits that the department is in urgent need of incumbents in the post of assistant executive engineer. But due to the operation of the stay order, the notification of promotion could not be issued till today. Therefore, expressing urgency on the ground of exigency of public service, the learned departmental council has prayed for vacation of the stay order. Mr. Goswami, learned counsel for the opposite party on the other hand submits that one post in the rank of assistant executive engineer be kept vacant, awaiting final order in the writ petitions. Mr. H. Sharma, learned additional senior government advocate and some is present on behalf of the state. In view of the projections made at the bar and considering the facts and circumstances of the case, this IA is hereby disposed of by providing that the respondents may go ahead and notify the promotion of departmental candidate to the rank of assistant executive engineer as per the recommendations made by the DPC. However, one post in the rank of assistant executive engineer shall be kept vacant, awaiting further orders passed in the connected writ petition filed by the writ petitioner. Needless to say, if the petitioner succeeds in the writ petition, his date of promotion and seniority will be suitably dealt with by the order of the court. With the above observation, IA stands disposed. You also have an IA, Mr. Day? You also have an IA for? Huh? But please come prepared on that.
If possible, 7. Eight.
Lordship may fix this matter on 4th. Lordship may fix if possible on 8th.
Okay. Writ petitions to be listed on 8th of August.
Public.
Item 7.
He'll come.
My lord, award of the labor court is in this challenge.
That's correct, but there are part-out matters.
Yes,
Why is he calling?
that's why I'm at my lord's disposal. I'll be happy to get more time because I have not read the evidence. But otherwise, I'm ready. I went by the notes of late S.N. Sharma. My lord.
Advantage. He's taking
My
advantage.
lord, this was the brief being handled by late Suren Sharma. His notes were there. So meticulously, I read his notes.
Okay.
So, but evidence, yes, I'll get the advantage. If there is
Now,
more time,
all
I'll
that
get
you
the
are getting
evidence.
time, what will you do now?
No, I can, otherwise I'm prepared. I can argue this case, but it will take a lot of time, yes. Because it's, the ground is perversity. There are, I can explain the whole thing. There was a strike by the labor union. And consequent to strike, there was a lockout declared by the management. Now, the labor court has held that the strike was unjustified. While holding the strike unjustified, the labor court has also held that the lockout was also unjustified. That, my lord, straightaway runs counter to the very scheme of section 24 subsection 3. That's one aspect of the matter. The other aspect of the matter is, by holding that both the strike as well as lockout were unjustified, my lord, the labor court has applied the doctrine of apportionment of blame, that both of you are blameworthy. So 50% of the back wages were awarded to the laborers. So, my lord, the very finding of the labor court that the lockout was unjustified is under challenge on the ground of perversity. Additionally, my lord, we have also taken a plea that the reference was stale. There was a delay of approximately 7 to 6 years in making a reference. So that's another ground. This is, my lord, what the case is all about, the core of the case. Obviously, my lord, we will go into the perversity, into the evidence.
NCR will be required, is it?
I was told, my lord, that the lower court records are very much here. Subject to correction, of course.
Can you agree on a date? It has to be in September or October somewhere.
My lord, he's elder to me, so I'll go by his convenience.
No. That's your lordship convenience.
My lord's convenience.
Your lordship may finally go through the award first, then your lordship fix it.
All right, Mr. P.K. Tiwari, and senior counsel for the writ petitioner, as well as Mr. A. Dasgupta, and senior counsel appearing for the respondents, have both submitted at the bar that this matter is ready as regards pleadings, and the LCR has also been received. As such, the writ petition be fixed for final hearing on 7th of September 2023. In view of the request made at the bar, registry is directed to list the matter for hearing on 7/9/2000.
My lord, I was told the interim order is also there. There is an interim order.
Interim order passed earlier will continue till then.
Lordship fix 7th August.
7 September. Why?
Because of the interim order, that we are not getting our benefit, that is 50% back wages. Payable to a large number of employees.
It has to be heard finally. Final hearing is required.
All right, so
If you want to file an IA, then you file an IA.
no,
Time being will not be possible today.
Can
Then
it be on the second lordship?
Huh?
Can it be on the 2nd of August lordship?
on the prayer of Mr. M. Dasnani, counsel for the petitioner, this matter is directed to be listed again on 2nd of August 2023.
Obviously.
Well, the issue here relates to the reservation within the category of civil costs for the PWD, people with disability. My case is that there is an excess reservation. They have kept one excess reservation for PWD categories in my SC category. That is why I am deprived. What happened here, Lordship will find, there was an advertisement for filling up of post 344 at page.
So you will be conducting final hearing of the matter.
Well, it appears that it
We'll do it then, but after the parted matters, there are parted matters listed.
will it be possible if possible today?
I don't know how much time the parted cases will take.
If there are more than
There are how many parted cases? Huh?
If otherwise not possible today because of those patterns. Any day next week or after the 11th only, because in the meanwhile I'll be out of station for 2 days.
No, I can't say how long the parted cases will take,
That's
but
true.
then we have to first finish the parted matter. What is the point in starting another hearing? Yes. Otherwise, ordinarily, we'll admit it and post for hearing. If that is what you agree, then.
My lord, only thing I am hanging, my lord, we'll have it on a convenient date.
Hmm.
But the only problem herein is, my lord, the contentions that have been advised. In the advertisement, it was set 14 PWD posts. There was no subclassification there, my lord. Thereafter, when the selection was made, I am visually impaired. 2 visually impaired got selected against because they were general. They were adjusted against general. I was an SC, so I was adjusted against SC. And accordingly, the list was published. Then there was a stay order passed by this court for which my appointment till date could not fructify, my lord. And I'm hanging. But my lord's judgment is also there, wherein my lord said that there cannot be any subclassification in the advertisement. They cannot put 5 posts PWD for OBC, 5 posts for. It should be general. Whoever comes in, my lord, gets horizontally gets fitted in. That's the basic issue here, my lord. I filed a vacating application also. And that is also pending, my lord. Application for vacation of the interim order, wherein, my lord, 1 post reserved for SCPWD was kept in abeyance, my lord. So, my lord can have it on any.
Mr. Mahanta, have you seen the judgment?
My lord, I can
I've
give
seen
it. Saidur Rahman, my lord.
Is it covered?
I'll go through it. No, not covered.
It's
That if this is applied even, then they will have to show how the posts have been distributed amongst all the groups.
I can show it straight
That is
away.
what is required.
It's there in the select list.
If there is no specific mention regarding the number of posts to be allotted in respective categories, then they'll have to show how they have distributed those posts in all the categories. So 1 post, otherwise 1 post is available for SC category. Now they have brought in 2.
No, see, let us just look at this. The law, as far as the judgment is concerned, and
Saidur Rahman.
otherwise also, is that in case of PWD category candidates, you have to go strictly by merit. No SC, ST, OBC, nothing.
Hmm.
If there are 5 posts, 5 in order of merit will have to be appointed,
Yes.
first 5. That is the law.
Hmm.
Correct. So are you saying that someone who has scored more marks, less marks than your client has been appointed as a PWD category candidate?
He is not a PWD, my lord.
Then,
I am
He
not
is
a
not a
PWD. I am SC simpliciter.
okay.
I am above him.
Hmm.
1 person has already been brought in from PWD to my category. He has been fit in. I have no objection to that. Even then, I get, but they have brought in 1 more PWD. That is where my objection is. That
is beyond the quota.
Yes, beyond the quota. That is.
There cannot be any quota, my lord.
They
Subclassification,
could not have
merit, whatever is my.
They could not have placed 2 PW candidates in the SC category when they have already given 1. Only 1 is to be entertained there. As my learned friend says that he was, first one was.
It is what, 4%?
4%.
What is the reservation? 4%.
And that too, law says that on the basis of the cadre stack. On the basis of the cadre stack.
So 4% will be how many posts?
Only 1 here. It accommodates
Total
0.48. Here, my lord, calculation
14.
for me 1.48. So let us take it 1. 5. 1 only. They get 1, and 1 has been given. The other one, they have brought in. That is my objection. That is why this honorable court, the collateral bench, heard the matter and found that no, probably there was something wrong there. Therefore, the order was partly vacated relating to the women category, because women category was also there. Then subsequently it was vacated, women category. I have no claim against the women category. So that was vacated, but then the PW category, 1 post, that was kept. And I hear the prima facie case that they, unless they can show that 2 PW candidates can be accommodated amongst 14 SC simplest, then matter will be different. But that cannot be prima facie. Accept it now. This is not, because it admits only 1, going by the 4%. Therefore, it needs to be hard. And if it gets hard and decided, well, either way, if he gets or I get, we get it. All are suffering. That is why I say, subject to your lordship's convenience.
My lord,
Time will be
page
required.
26 is the advertisement, and therein it says 14 posts, general, 320 posts were advertised. So for 14% works out to be around 14, 12 would be, maybe there were other reservations, so 14 posts.
Well,
Then, my lord, the select list, my lord, would find at 40. They have, my lord, adjusted people with regard to visually impaired. Page 26, my lord, would find junior engineer civil. Last column, my lord, post reserve for PWD and type of disability 14, blindness 4, deaf and hearing impaired 4, locomotor disability 3, autism 3. So this was the breakup, my lord. Now your lordship comes to the select list at page 40. My lord would find from page 45 onwards. Serial number 213. My lord would see serial, that's the first PWD, orthopedically handicapped. The next one is at serial number 219, both general. Then my lord would just skip over to page 47. 293, that is, my lord, general, visually impaired, first one. Then 310, general, orthopedically handicapped. 313, VI, visually impaired. And hearing impaired is 315. Now, my lord, the last page, 48. Herein, serial number 317, my lord, is an SC. He belongs to hearing impaired. 340, page 48. 317, he belongs to hearing impaired. Whereas, my lord, the applicant before my lord is 318, Suman Das, SC, visually impaired. Now, my lord will see the note down below.
Yes.
My lord, the second one, my lord. There were only 3 PWVI categories against the required 4 candidates. Also, there were no candidates for PWD autism category. So, my lord, out of the 14, 3 for autism was not filled up. And for VI, only 1 was filled up. So, in total, my lord, only 10 persons PWD were appointed. And they were not, my lord, this was subclassification was not made in the advertisement. This was made on merits. Merits, whoever they, whatever caste they belong to, my lord, they get adjusted. That's the ratio, my lord, which my lord has, the Supreme Court has also said that. So, my lord, there is apparently no error here. So there is no point, my lord, keeping my appointment in hanging. My lord may decide the larger issue if required, my lord. But in the meantime, there is no requirement, my lord, prima facie, my lord, my submission, to keep my appointment in abeyance. Because this was kept in abeyance on a wrong notion of the matter, my lord. One SC.
So if you don't get appointed, he will get appointed.
My lord, my lord, he's because his name is not there in the select list, my lord. Because he was not selected.
my name appeared in the first select list.
He said he's the next below, but that
Next
material is
below?
not before your lordship.
Next below the, my lord, appoint.
That's what his
Last
stand is, my lord, but
appointed
that there is no material.
Where is the name of the petitioner?
Yeah,
First list lordship will find. Page number 33.
Page number 33.
Yes.
that is the list, short list for interview, my lord. Screen.
So my name, my roll number appears at page 33, my lord. 50516. That is my roll number. This is the first list. Then they were asked to appear for verification. And verification, they have done. In the verification, the final list appeared. And there, they have shown the categories. And there, lordship will find.
So this is the list of candidates for document verification.
Huh.
But where is the select list?
Select list, that is what I was taking my lord through.
Where
That is
the
at
select
page
list where the
40.
petitioner-
His name is not there, my lord. One of the APSC can clarify that.
My position
Wait a minute.
will come to last candidate appointed here. No. Yes, but I come under this. Petition again.
So your name is not there in the select list. The prayer is to include your name in the select list.
But because the last candidate, that is the PWD one, second, who has been brought in, if he is out, then I will come in the select list. My number, my merit position is this.
No, Mr. Mohammed, what I wanted to know is that these people have been included in the select list because they are PWD candidate, or they have been included on merit, but they belong to a particular PWD candidate.
They have been included because they are PWD candidates. Because that quota,
So why is that serial number 310?
Lordship.
Why is her name at serial number 10 and not 299? Why it is in that position? What is it?
310, my lord.
Yes, any candidate for that matter.
I think, my lord, this is because this is of PWD, my lord.
Oh, orthopedically handicapped.
Orthopedically handicapped.
So this entire list is of PWD.
No.
It is a
General,
merit.
merit list, general, then my lord would find the reservation, my lord. Then the reservation, my lord will have 310.
Roster has been operated.
Yes, your lordship. My lord will have 310.
What
My lord
roster?
will-
20 point.
No, Lordship.
Then
Lordship, I'm claiming. Lordship.
My lord will have 310, my lord. Serial number 310 at the merit list.
No,
My lord-
Mr. Nayan, I'm trying to understand one issue. Please address that. This is a select list, is it not?
Lordship,
The select list is prepared on what basis?
it's on prepared, my lord. That's why I'm just trying to clarify. My lord will have page 40, my lord. I'll just clarify that, my lord. So there were around 320 posts, my lord. So half of that is 160. My lord will just come down to page number. My lord would see from page 40, open category. All open category, it goes on till 93. Thereafter, my lord, the reservation starts. Once that reservation starts, it goes on, and the culmination, my lord, in the end, they have included the, my lord, persons with PWD. And this is not disputed by the petitioner also, my lord, the positioning here. And in the affidavit of the PWD, the APSC, they have taken a stand at page 74 that he secured 127.75, 127.25, whereas the cutoff was 127.75.
Who secured 127.25?
25.
Who?
Petitioner, my lord.
Cutoff for general or for
SC.
SC. For SC.
SC.
SC Simplicita. The last candidate, Simplicita, appointed. He secured that the 127.75. He is at page 43, 150, serial number 150. This is the cutoff for Simplicita. And my position is, my next below is me. Because my number is 127.25.
So between 127.75 and 127.25, no one else.
No,
is there.
no
He'll
one,
be there.
no one.
My lord, if my lord tomorrow holds that the reservation given for the orthopedic or for the PWD is not permissible, then my senior's client may come in, my lord. But if that is permissible, then I will replace him, my lord. First, they prepare the list of SC candidates on merits, my lord. Then they see if there is any PWD who is having that. Then they get adjusted, my lord.
The matter will have to be heard.
Lordship.
That is why Lordship earlier.
And if the APSC also can produce the records, my lord, pertaining, that will also, my lord, clear the issue, my lord.
That is required.
My lord may fix a date when my lord's board is permitting, my lord, we'll
Board will permit next year. Or maybe the year thereafter.
Even the Lordship will give us some priority so that.
No, he said when board permits.
I withdraw that.
You say listed when the board doesn't permit. That is the better. That is a much better proposition.
Understand.
Mr. K.K. Montal and senior counsel
Abhi respondent given.
and Begum appearing for the lead petitioners. Also heard Mr. U.K. Nayan and senior counsel assisted by Mr. M. Sharma, learned counsel appearing for respond number
7, my lord.
respond number 7. Mr. P.P. Datta, learned SC, APSC.
3, 4 and 5. 3, 4 and 5.
Respond number 3, 4 and 5. Whereas Mr. P. Nayak, learned, you are appearing for?
For the department, 1, 2, and 1.
This is which department? PWD.
PNR.
Second council PWD. Assam is present on their respond number 120. After hearing preliminary arguments advanced at the bar, this court is of the opinion that the matter can be finally decided on perusal of the relevant records to be produced by the APSC. In view of the above and as requested by learned counsel for both the sides, can you suggest a date?
Well, August later part, Mala, on 29th or 22nd,
29th August?
22nd August.
Facilitating the above, let this matter be listed again on 29/8/2023 as a fixed item. The learned standing council APSC to produce the records on the next date.
Mostly may indicate that IA is harping all the time. Earlier also the same thing happened. That will be hard on that day finally. Now,
The IA filed by the respondent number 7, recap pending and shall be considered.
interim order shall continue.
Interim order passed earlier to confirm.
Oblige.
And then
So this is a case for selection to the post of administrative officer in the district of Baksha and appointment. I have challenged the selection and appointment on the ground that 15 years of service is the main minimum qualification for the post of administrative officer as per rule, as per advertisement. The person who has been selected, Ratul Talukdar, he did not have the qualification of 15 years of service on the last date of filing application. That is the first ground. On last occasion, on earlier occasion, Lordship has allowed us to inspect the record regarding merit position also. I have also verified the merit position. I have filed an affidavit to that effect. Now, I will take your Lordship to the advertisement.
No, you are arguing for disposal.
Lordship.
How much time will it take?
Half an hour. Minute.
Then after the parted matters, you wait. I'll have to finish off the parted cases, deliver judgment. then-
After that, Lordship.
Huh?
After finish of the list. Lordship. No, finish of the list.
I think 11 to 30.
Lordship, in this case, Lordship, the learned AG is appearing, Lordship. In this case, we are supposed to file affidavit, Lordship. Due to some one officer's Lordship, murder has expired, Lordship. So affidavit could not be filed today, Lordship. Due to some
Matters.
My lord, this regarding the termination
of
of the
illegal
APC
employees, Lordship. Termination of illegal employees, Lordship.
Termination of employees, my lord, on this moment.
Termination of
AFDC.
AFDC.
Assam State. AFDC employees, my lord, termination. Regarding that, we have challenged.
Only
the
10 days
termination.
time required, Lordship. I will file.
My lord, 10 days. My lord, a little shorter period.
Heard Mr.
Jay Singh, lord.
J. Singh, learned counsel, who is present on behalf of the petitioner in all these petitions. Mr. P. Sharma. You are appearing also? Which case?
And I don't know 12 months.
Item number 12.
12.
So J. Singh for 11 and 13 and Mr. N.J. Khataniya for item 12. Also heard Mr. P. Sharma, learned SC AFDC, who submits that due to a medical emergency in the medical emergency faced by
One of the officers, Lordship,
one of the
murder has
officers of the
expired.
AFDC. Now, due to an emergency, no, you're right, due to a bereavement faced by one of the key officers of the AFDC, namely the death of his mother, the counter affidavit could not be brought on record. Mr. Sharma therefore seeks posting of this matter again after 2 weeks, just to enable him to file the counter affidavit. Having regard to the ground on which the prayer is made, The same stands allowed. Registry to list these matters again after 2 weeks as fixed item. The counter affidavit on behalf of the ALDC be positively filed within 10 days from today by serving advance copy upon the.
Doctor, may I pray on in this? Learn easy, Podman.
Okay, just taking time.
Go there and sort it out. I pass the order. Yes.
Item 49 is there.
My lord, Mr. Dilip Majumdar had some problem. My lord, he informed me. My lord, he informed me that he will not be in a position to do these matters today. My lord can have it next week or the week thereafter, my lord, subject to.
So you can have Leonard Senior Counsel is present only the petitioner, however, in view of the personal difficulty expressed on behalf of Mr. D. Majumdar, Leonard Senior Counsel appearing for the respondent number 4. This matter stands adjourned for two weeks. Registered to list this case.
My lord, the
after
man
2
is
weeks.
retiring on 31st.
As
If a
a
date
fixed
can be.
item.
A
After
date,
2 weeks as fixed item.
lodge.
Procedural is for order, item 16.
Fixed item.
32. Item 32.
The same matter, this along with.
Yeah, please, your lordship. In compliance of your lordship's orders, the respondent has filed the affidavit, my lord. And page 34 is the directions.
Order has been complied.
No, my lord, that is the, now their contention is that we have not filed the application.
Along with. Along with. Yes, what happened here?
Their contention is that we have not filed the application before the appropriate authority. There are the directions to the petitioners to file an application before the appropriate authority. An appropriate authority will decide the matter within 2 months. That is page 34. And we have submitted our application. And they are now, by filing this affidavit, they said they are not the appropriate authority. They are the director, they are the appointing authority, they are the controlling authority.
Who is the appropriate authority?
Now, they have not stated it.
You are appearing in this case, Mr. Nayak.
32, Lord. Lordship, in this case, we have filed my affidavit, Lordship. Here, Lordship, the court's order was furnished to the Director, Geology and Mining, Lordship. And at that point of time, Lordship, I was not the Director, Geology and Mining, Lordship. And the then Director, Lordship, forwarded the order, court's order, Lordship, to the government, Lordship, for its consideration. Thereafter, Lordship, when the contempt was filed, Lordship, and a notice was issued, I again wrote another letter to the government, Lordship. Lordship, I kindly see that letter in my affidavit, Lordship. Only one annexure is there, Lordship, at page 43. Page 44 is the relevant portion, Lordship, last
So
paragraph.
according to you,
Lordship, it's a issue as regard whether they are applicable, old pension scheme is applicable to them or not, Lordship. It's a decision to be taken by the government, Lordship, at the government level, Lordship, not by the director, Lordship. That is my only issue, Lordship. And in the writ petition, Lordship, principal secretary was a party, Lordship, government was a party. So if he impletes up, and right now, Lordship, I am not holding that post also, Lordship. I am now transferred out of that post, Lordship. Some other person is holding the post of director, Lordship.
why don't you implement the government authorities?
Yes, Lordship.
Serve a copy, demand compliance and implement. If you don't want to do it, then we'll post it for hearing someday. We'll.
No, if they say that the government is the appropriate authority.
No, then that is your contention. We'll have to apply our mind. Maybe you are right, maybe you are not. That cannot be decided today. If he takes that plea, we'll decide it. Contempt will happen only when there is a deliberate violation.
Already they have written to the government also for approval possibly. That whether we can be considered or not. Now,
what do you want to do?
Now, can it be
We'll decide after 2 weeks, we'll post it again. It will take
They
you time to
permitted to add the government.
8 to 19.
Yes,
And
on the prayer of Mr. Alan Hawk, learned counsel appearing for the petitioner. These matters stands adjourned for 3 weeks so as to enable him to file appropriate application for implementing the concerned government officials who is responsible for implementation of the court order. After demanding compliance of the court order, from him. Mr. P. Nayak, Nayak Council is present on behalf of the sole respondent.
Obvious.
All right, rest of the matters will have.
May I please, Your Lordship. Your Lordship, in this present petition, there are 4 writ petitioners who are contingent employees of the ONGC, and they are seeking regulation under the certified standing orders in contingent employees framed by ONGC. Your Lordship. So, Your Lordship, what has happened? There is no dispute that these 4 persons are working. Petition number 1 is working since 2000. I'll give the chart. I'll give a chart, Your Lordship. There, 2007. Petitioner number 2 is working as contingent employee since 2006.
Yes. Yes.
And petitioner 3 and 4 have been working as contingent employees since 2010. Till today, they are working continuously. Your Lordship. Under the certified standing order, a workman who works for 180 days in a month or 240 days in a year, 180 days in a year or 240 days, they are entitled to be regularized under the standing order. And this standing order has been enacted pursuant to this Act of 1976, Your Lordship, this Employment Industrial Employment Standing Order Act 1946 in view of Section 10 of that Act, Your Lordship. Then this Act was enacted, Your Lordship. These people have been working since. What has all this litigation has a exchequered history, Your Lordship. In fact, this ONGC has a habit of employing contingent workmen like that, and thereafter they engage some contractor for a period of 3 years, and they look after this. They pay the salary to some of them. So giving them a class that these are contract laborers, which is not so, Your Lordship. Here, what has happened, there are 3 awards which has been passed CDIT from time to time, which went through this honorable code also and has been confirmed by Apex code also, that this contract which has been entered between the management and this thing are sham contract, and these people are entitled to be regular. These 3 judgments are there, which I have put in, Your Lordship. Supreme Court said this they should take, these are perennial, these are seasonal, not perennial work and that thing. But it has been found that ERBC, which is the Eastern Region Business Center, which Lapua and all this eastern side, their project has started from 1963. The township has developed, everything has developed. It's a permanent school, everything is there. So the court has said it's perennial nature and they are entitled to be regularized, Your Lordship. All the judgment, I'll refer to the judgment, Your Lord. Three awards that is got, and Your Lordship has had the occasion to deal one of the matter also, where you have regularized some person who has retired and they are not given the benefit. Your Lordship has given a judgment to the effect they could give them the benefit of that. This is Bopanna's judgment, Your Lordship. Bopanna's judgment, which came from Supreme Court, it was affirmed by Supreme Court also, Your Lordship. Those are all here, Your Lordship. Now, what has happened, Your Lordship? The fee of the respondent is said they have adopted fairness policy. Fairness policy, which has happened in Gujarat, Your Lordship, Western, they extended here and they entered this agreement with 2 trade unions and one of the contractor, Your Lordship, who is no longer the same. So according to that, some wages have been done and their conditions are there that they won't file any litigation against the ONGC, all these things, conditions are there. Then, Your Lordship, this fairness policy is only for the period, it has expired in 31/3/2017, it has not extended. Now, what has happened? People who are not members of the association, some of them, they have just to get fair wages, they sign some papers. And if Your Lordship would see the form here, that is totally blank and this thing doesn't show it, Your Lordship. So these are the aspects of the matter. Then what happened, Your Lordship, from time to time, and Your Lordship, they said, we are engaging contract labor, these are contract, but there's no license under there's total violation of the Contract Labor Abolition Act, Regulation Abolition Act 1970, which will show that they cannot come under this thing because these people are not having license under Section 12, Your Lordship. Because contract labor has does certain things. Now your lordship, why I'm saying there is a direct control of ONC, because under the Contract Labor Evolution Act, contractor need not pay EPF, provident fund, everything. But here ONC is paying through the contractor, your lordship. So if that is so, then the Contract Labor Evolution Act not is applicable, your lordship. Then your lordship, under the scheme of the act, your lordship, that if a contract, there is a chapter 13, schedule 13, your lordship, where the contractor has to give the list of workers, that these are the workers working under me, which is not there. That admittedly these are not there. And licenses, neither the ONGC has having license, nor I have made a category, they have not denied it. Neither they have a license, nor the contractor have license to engage contract labor. So once this contractor has been engaged just to defray the regular salary to us, your lordship. And this contractor, if you're lucky, there for a period of 3 years, then subsequently someone will come. ONG says, these are the, you take this employee. So contract labor, generally the contractor brings the labor and engage it. Here, the ONG say you engage them. So it's the other way around. So that shows these are not contract labor at all, your lordship. That is all. Then your lordship will see these people are working in a skilled job and they have been controlled throughout by ONGC also. There is a total employee relationship between them, your lordship, as a result of which they are entitled to the benefit in terms of effects for judgment of that. I have given the judgments also. So these are the aspects, your lordship. Then your lordship will see that under the this executive standing order 1962, that has been dealt by the apex for the two judgments. I'll refer to those judgments also, where they said you have to regularize them under the clause 2 of the standing order, your lordship, that talks of regulation, that if you comply with this condition, you have to enter for regulation, your lordship. That judgment, two judgments of apex court are there, which has said that this thing, even the other judgment, an award from Kachar, which I have referred here itself, that also has relied on standing order. Supreme Court has affirmed that order also, your lordship. Supreme Court judgment is that is 2008, that is 2014, I think, no, your lordship, that is 2008 or something like that judgment. Supreme Court judgment is there. That is referred by in the division bench of Justice, Honorable Justice Bopanna and Justice Goswami, your lordship. So that all these things are there. So now, your lordship, this what is happening, your lordship? They have the plea of the respondent is, since we signed the fairness policy, we have deemed admission that you are contract labor. Secondly, they took the plea of estoppel, that once you have said estoppel, your lordship knows there cannot be estoppel against the law. And if your lordship will see this, the standing order has been enacted under your lordship section 10 of the Industrial Employment Standing Order, your lordship. Now, your lordship, under the ONGC Act, section 30A gives them the power to, they can modify the standing order, they have the power to, but they have not done it. And your lordship, what they are trying to do, Supreme Court has held also, that a policy decision cannot override the standing order, your lordship. Standing order is a statute, so it cannot be. Here, they want to override standing order of a fairness policy. Fairness policy is a settlement which is something that is much a lower inferior, not a policy also. Fairness policy, what they are trying by the implement a fairness policy, they are nullifying the effect of the standing order, that they are not because they have deemed admission. So this is the main crux of the matter, your lordship. So then, your lordship, may I take your lordship to, because there are documents to, I have placed on a lot of documents which shows they are a contingent employee and they are a direct employee of this thing. Some checks have been issued in their favor, everything. And what they are doing, they are putting some contractors here and there without, there is no statement by them as to who are the contractors who engaged him. This 4 person. There is no statement to that. They said they are contract labor, they are other contract, but no name of contractor, no license of contractor has been annexed, your lordship. And there is no statement that this contractor are having license. Even if your lordship will see the agreement one agreement which they have given with the contractor, the ONGC, where there is no condition that they have to have a license under section 12 of the Contract Labor Evolution Act and this thing. And so that is not there. Even your lordship, the subsequent contract, one contract they have 2018, which has not referred to fairness policy at all. So that here is a dichotomy arises, your lordship, as to what, because fairness policy they have given up because they have not extended it. So that is not in existence. So you cannot rely on fairness policy today to deprive me that regulation of contingent employee, your lordship. Then your lordship will see even the fairness policy, your lordship will see the condition specified is that the contractor doesn't have the right to terminate and contract, the terminate of any of the workmen. It is the ONGC where that I'll show those provisions also. So that is there. So your lordship, now here the issue is whether they are on direct control and supervision of ONGC or not. The issue is in terms of this, they are the direct employees, they are being direct employees of the contract of the ONGC, and they are contingent and not a contract labor, contract worker. That's the issue. So here, in terms of this, they are claiming that there should be regulation service in that. That's the sum and substance of the matter, your lordship, basically. Then your lordship, if I take your lordship to the award portion of the award, which I will show you, your lordship. If your lordship, may take to that certified standing, page 59 started, page 59, your lordship. The contingent employees of the commission shall be herein be classified as temporary and casual. Then your lordship says a workman who has been in the role of the commission and has put it not that it should be 180 days, typical is 130, so 180 days. 180 days, your lordship, that's my mistake, your lordship. Of attendance in a period of 12 consecutive shall be a temporary workman, provided that the temporary working was put not less than 240 days and who possesses the minimum quality prescribed by the commission may be considered for conversion a regular employee. Here, your lordship, may have posed, your lordship. Here, I have made a category. I have been working continuously for throughout the year, your lordship. Only the Sundays.
So we'll ask them to consider your case by examining whether you have.
Yes, your lordship.
That's all. Standing order as per standing order. What is the point in going here and there?
Yes, sir.
So far the standing under is concerned, my lord, that 240 days working, my lord. If it is directly engaged by the corporation, my lord, then it may be a case, my lord. But here the petitioner himself, my lord, admitted that the engagement by the contractor, if it is engaged, if they are being engaged by the contractor, my lord, their case is covered by Contract Labor Regulation Act, my lord, 1970. And in that case, whether there is master servant relation or the, my lord, agreement is same or not, that has to be decided by the labor court. They should approach the labor court, my lord. My lord, this is the judgment in Kiloskar case 2023, my lord. The small judgment, just I want to place that.
I've got a copy of that.
This is the, my lord, there's exactly the same case. No, I have placed it. Exactly the same case here, my lord. The termination was challenged before, then the labor court said no, they are entitled for reinstatement, regularization, no termination. But these persons were also engaged by contractor. Now, my lord, para 13, my lord, if lordship directly come to para 13.
1 minute.
Yes.
Don't be so excited. Your contention is that regardless of whether they have worked for 240 days in a year
under contractor,
their service was rendered under the contractor and not under the ONGC.
Yes.
Correct.
Yes.
But according to him, this engagement through contractor is nothing but a via media adopted by the ONGC just to ward off its liability.
Yes.
As in reality, the petitioners have been in engagement under the ONGC only and not the contractor.
Right.
This is a disputed question of fact.
Yes.
In read petition, how it will be decided?
Yes.
It has to be decided on the basis of evidence.
Yes. Para 13, my lord, that says, my lord, this judgment, my lord. Para 13.
1-3.
1-3, my lord, paragraph, my lord. May I read this para, my lord, small para? In International Airport Authority India versus Air Cargo Workers Union, after considering the decision of sale, National Union of Waterfront Workers, it has been observed that and held by this court that where there is no abolition of contract labor under section 10 of the Contract Labor Regulation Act, but the contract
the labor contents that the contractor between the principal employee and the contractor is same and nominal, and the remedy purely under the ID Act, my lord. It is further observed that the industrial executive can grant the relief, so it finds that the contract between the principal employee and the contractor is same. Nominally merely composes deny the employment benefit to the employee, and there is in fact a direct employment by applying this test. Like who pays the salary? Mala, these are the consideration. Who pays them the salary? Who has the power to remove this from service disciplinary acts? Mala. The way in which the work should be done, means who has direct control over the employee. These are the considerations, my lord. In such cases, this has to be proved before the labor court by adducing evidence. Here, my lord, in the affidavit, we have placed on record the contract agreement between the contractor and the management. And these persons in the repetition as well, they accepts, my lord, that we were been engaged by contractor. Now, he says, for deny the benefit, this contractor has been shown, but I have placed on record the contract agreement. So if he wants a regulation or consideration for case for regulation, he has to place it before the labor
You are
court.
not open to going to the labor court, is it?
Your lordship, this thing has been determined already, your lordship. This thing has been already determined, your lordship, by the judgment of apex court. Here, this also, because because they have first thing, because here the contracts entered between, I'll show from the award also, is sham, and this came out from justice.
Hear it.
Yes,
Today
sir.
it will not be possible. Some other day. Heard Mr. P. Chaudhary, learned counsel appearing for the writ petitioner. Petitioners also heard Mr. B.K. Das, learned counsel representing the respondent stroke ONGC. The four petitioners herein claim that they have been continuously engaged as contingency worker under the ONGC for more than 10 years at a stretch. Not only that, the petitioners claim to have worked for more than 240 days.
Yes, sir.
In
Any
calendar year, and therefore, as per standing order, as per the certified standing order for contingent employee of the ONGC, more particularly clause 2, their services are entitled to be regularized.
Clause 2, your lordship. Clause 2 of the standing order.
That's it. As such, the present writ petition has been filed seeking a writ of mandamus. Mr. B.K. Das, learned counsel for the respondent, on the other hand, submits that the petitioners are all engaged under a contractor and they are not under direct employment under the ONGC. As such, regardless of fulfillment of criteria laid down in clause 2 of the certified standing order, the petitioners cannot claim a writ from this court directing regularization of their services, contending that there are contract agreements executed by and between the petitioners and the
Management and the contractors.
management of ONGC and the contractors permitting engagement of such contingent workers.
Your lordship is fixing a date of hearing also.
Yes. Mr. Das has further argued that if the petitioner denies the above status, then the same would be a purely disputed question of fact, which can be adjudicated by the Industrial Dispute Tribunal.
Yes.
In support of his above argument, Mr. Das has relied upon the decision of the Supreme Court rendered in the case of Kirloskar Brothers Limited versus Ram Charan and others, reported in 2023, bracket close 1 SCC 463. Mr. Chaudhary, learned counsel for the petitioners, on the other hand, has strongly refuted such arguments and submit that the contract agreements are merely nominal and scam transactions, which cannot abridge the right of the petitioners crystallized under this standing certified order. First, be that as it may, after hearing the submissions advanced at the bar, is quoted with the opinion that the writ petition would require deeper hearing. As such, admit the petition. Since the respondents are already represented, no further notice is required to be sent in this case. It is submitted at the bar that the writ petition is ready as regards pleadings. As such, registry to list this case for, choose the date in September.
Not 31st August.
We'll list it, but that day you have to tell us the next date. Because the matters are piling up.
Yes, I know, I think. Give it.
You want to come to Guwahati, you can choose any date.
31st August, your lordship. 31st.
Yes, but it will not be taken up on that day, but you come.
It will be for fixation of date or what?
Ah, yes.
Would your lordship fix 1st week of September? I don't mind.
First thing, there is some vacation also, 12th of September, if it is
12th of September.
convenient, it is Tuesday.
For final hearing. As a fixed item.
My lord.
12th September,
Yes.
good time to come to Assam.
Obliged.
I'll try. If I get stuck up, I'll take time in that.
Yes, yes. No, we want to list it when it can be actually heard.
Yes.
There is a limit beyond which we.
Yeah,
can-
I know the difficulty. I know the difficulty. I'm highly objective.
Yes.
There are a lot of judgment on the, I think, several judgment on the other issue also. Clause to
We have to hear it. These are contentious issues.
May I please?
Hmm.
Malad, these two matters, issues are same. They are employees of KVK, Kisan Krishi Vigyan Kendras. It's there all over the country, madam. It's done either directly by ICAR, Indian Council of Agriculture Research, or through host institution. Even NGOs can run it. In Assam, my lord, this is run by NGOs, by the Assam Agriculture University, and my lord, ICAR themselves. Now, what we were being given, my lord, the pay scale is prescribed by the ICAR, and we get that, along with the allowances. Now, with the coming into force of the 7th CPC and adoption of that by the ICAR, my lord, the Assam Agriculture University also revised our pays for, my lord, the persons in the KV case, who wanted to opt for ICAR scheme. And we were given that. This proposal was sent to the ICAR. ICAR accepted that. 2018-19, they released the payments to us. Now, all of a sudden, our organization, my lord, makes up nowhere connected with any of the activities, my lord, makes a complaint that how can you have two pay scales, one for the Agriculture University people and another for KVK. So you are discriminating against the Assam Agriculture University employees. This cannot be done. They write to the respondent number 3 here, who is one of the directors of the controlling institution of ICAR here. He does not respond. Second complaint goes. Then all of a sudden they say, don't pay this allowances, only the allowances. Pay scale, there is no dispute. Don't pay. Allowances are, my lord, non-practicing allowances for veterinarians, special duty allowance, which is applicable here, SCA, traveling allowance. Then, my lord, they release the amount, saying with a note that only for Assam Agriculture University KV case under Assam Agriculture University, don't release it. For all other institutions in the Northeastern, my lord, they are paying that without any objection, my lord. Then we bring on record, my lord, Annexure 22 series, wherein my lord would find even in West Bengal, which is a similarly situated host institution is running, therein also all these dues, SDA is not applicable there, SCA is not applicable there, but NPA is being given. Now, my lord, in spite of this homogeneity that is there in all institutions, we have been deprived. And they have filed an affidavit, my lord, peruses that there is nothing, that there was a policy decision to stop it other than this complaint. This complaint when they acted on that. No, we are not paying. And in August 22, this affidavit was filed. They say, we'll also take a decision for the other KV case. Till 1 year around now, past, no decision, all are being paid. We have been deprived. And the only stand in the affidavit is that Assam Agriculture University employees are not getting. That complaint was, my lord, by some hurt burning of those employees in Assam, that they are separate, my lord. They are totally separate and we are separate. We are 100% sponsored by the central government. This is basic the case, my lord.
Why two writ petitions?
My lord, because one is with regard to the technical stuff and others are, my lord, with regard to the office stuffs. So we have brought in two writ petitions.
And where are the impugned notifications?
My lord would find the first notification which have been impugned. My lord would have it at page 128, man. My lord, please refer to Council's letter dated 3/3, forwarding there with a copy of the letter of so-and-so, President of so-and-so Assam, with dated so-and-so, seeking your comments on the issue of payment of so-and-so, special duty allowance, special compensatory traveling allowance to staff of so-and-so under Assam Agriculture University, Jorat. A reminder dated so-and-so was also sent in the matter. However, no comments have been. Subsequent to the above letter dated so-and-so has also been received from Bolenboisho so-and-so, which has been considered by the competent authority in the council, and it has been decided to immediately stop payment of non-practicing allowance, special duty allowance, special compensatory allowance given to KVK under the aegis of AEU Jorat from ICAR funds. However, so-and-so may act as per clause 7.3 of the so-and-so. It is therefore directed that payment of non-practicing allowance, special duty allowance, special compensatory allowance under KVKs under the aegis of so-and-so be stopped with immediate effect, and an action taken report may be sent to this so-and-so. Now, my lord comes to page 129, the response of the Agriculture University, my lord. My lord would have this second paragraph. Sir, the allowance as stated above has been granted to AU KKV staff as per provisions of the funding agency, that is ICAR. These allowance can in no way be considered as additional incentive, and as such not in violation of clause 7.3 of the MOU entered into between the grantee and the ISA. Sir, even with within the any region, the KVK staff under the control of other agencies like the government of Arunachal Pradesh, government of Nagaland, NGO sector KVK Dima Assaw are getting these benefits in long, not to speak of ICAR administered KVKs, KVK Golpara and Hailakandi. The decision of granting the aforesaid allowances was taken within the ambit of the agreement signed, wherein nothing has been said about non-entitlement of those allowances for the KVK staff under AAU. What exactly we consider is that at least the guarantee organization should have been given an opportunity to be heard before taking a final decision. The element of discrimination in giving benefits of KVK staff within the region may have some unhealthy effect also. Under this situation, I am directed to request you to look into, kindly have a relook on the matter and allow us to continue with the present arrangements of giving benefits of allowance to KVK staff under aegis of AU and obliged. Now, my lord, next page, they release the amount for the month, because they were releasing those amounts to us. Then, my lord, in May 22, 31/5/22, they make payment for all the, my lord, KVKs here. My lord will only have the note down below with an arrow mark, my lord, 2. DE Controller AAU Jorat, as per Council letter dated 2/5/22, non-practicing allowance, special duty allowance, special compensatory allowance, traveling allowance to staff of so-and-so under Assam Agriculture University Jorat will not be provided. Now, my lord peruses the similar situation in other institutions.
And where is the notification by which these were originally granted?
My lord, that notification is not there. I can show, my lord, one thing. My lord would come to page 107. And there is a statement, my lord, we were receiving it. No, my lord, page 107. This is the demand made by the Director of Extension, Assam Agriculture University. Breakup is at page 108, my lord. No, the quote has in notification. Page 108, my lord would see this was sent to the ICAR. 108, all the allowances have been spelled out, my lord. Basic, DA, HRA, MA, and then subsequently DA, HRA, MA. My lord would find in the right hand side, second row, NPA, SDA, SC, SCA, traveling allowances. Then my lord would see how they have reacted. My lord would have the mail at page 114. This is a mail received by us. It is instructed to all KVKs, ICR, Atari, so and so to kindly send the salary requisition for the month of March in the attached format positively by tomorrow, 6/4/2000. Salary will not be disbursed without submitting the information. This was by my lord, the director, ICR, who has filed the affidavit also. Now the format is at page 118, my lord. This statement will also not paragraph process to promote salary. Page para 17. My lord, page 118 is the format, my lord. My lord would find name, designation, pay level, basic DA, SDA, transport allowance, other allowances total. So this.
So only these allowances for the KVKs coming under Assam Agriculture University has been suspended. And others are.
All getting. All over India, NPA is being given. The other institutions here, my lord can have those pages at page 114.
Read petition, which is by the teaching technical and non-technical staff.
My lord. But 3974 by technical staff and 396422 non-technical one.
But grievance is similar.
Similar. All KVK employees, similar. We opted for the, I say, the AU gave us an option, whether you want to be with the ICA pay scale or you want to have our pay scale. The difference is, my lord, the pay scale of AU is higher than, my lord, ICA. We opted for ICA because we are getting this allowances along with that. That would take our pay a bit higher. And that made the heart burning. I need not show, my lord, the complaint. My lord reads the complaint, my lord will know it's motivated by somebody in the institute itself. Because otherwise that body has got nothing to do with this one.
What is that body? It's some.
Juba Satra Parikat.
What is Juba Satra Parikat got to do with this?
That's it, my lord. And they are acting on that, man. And they have justified in their affidavit saying that any individual can make a complaint. Page 125, my lord, is the second complaint. My lord can just have a peruse that, my lord. In the first complaint, it was more explicit that it was being made by somebody in the institute. Second one, they modified it to a bit, my lord. And the threat is that we will take legal, they will take legal action if this is not done.
So worst case scenario, what will happen? Say court says, then you pay them as per the AUA pay scale.
Lord. No, AU pay scale, then we will not be entitled to this.
But you will have a higher pay scale.
But we only have a grade pay, higher grade pay, madam. But we have opted for this. Option was given. There was a committee made. Option was given from page 87 onwards. Then, my lord, this were given. This was sent. Each and everything was communicated to ICA. Never objected to this. Finally, they released the areas with these allowances. We received it. All of a sudden, from May, they stopped it.
You've been receiving it since when?
My lord, since the date of revision, subsequently, my lord, from 1/1/2016. Para 17, I have said that one.
And it was stopped when?
May 22, my lord. Then immediately we approached this honorable court. The interim order could not be done because, my lord, the affidavits had not come on record. The affidavit subsequently came on record, and then, my lord, the matter was pending. My lord, I can show from the, my lord will only have one more document here, a series, my lord, at page 149.
149.
149.
Yes.
My lord would see, this is from West Bengal, my lord. The Honorable Vice Chancellor has been pleased to implement the revised pay scale of staff of so-and-so on the aegis of university in recommendation made by the so-and-so on 7th central pay with effect from so-and-so. ICA, the pay fixation as per the central civil pay for KVK employees under the aegis of this university to be made on the basis as detailed below. My lord would come to serial number 7, NPA. Because therein, my lord, SDA and SCA is not applicable. 20% of the basic pay with so-and subject to condition the basic pay plus should not exceed so-and-so. Then, my lord, 151, it's from Arunachal Pradesh. 151. KVK East Coming Paboli, which is run by the government. My lord was Sanjay Bhattakur working as senior so-and-so in pay scale. So his last pay for the month of 18 after revision as per so-and-so is as follows. Pay DA, SDA, TA, SCA, gross. My lord comes to 152. This is, my lord, Tirap, Krishi Vigyan Kendra Tirap, Government of Arunachal Pradesh, under. My lord would see this salary slip of one Narendra Kumar. My lord, it contains everything, my lord. DA, SCA, SDA, TAs, gross total. Then, my lord, comes to the page number, my lord, 155. This is with Tripura, my lord. 155 Tripura. It's also by an organization. My lord, therein also everything is being given, my lord. SDA, SCA, everything is given. This is a payslip of, my lord, March 22. And similarly, and all other institutions are getting NPA, my lord. But we have been so. My limited prayer, my lord, if the matter cannot be heard finally, well, at least that interim direction that we should be paid this subject to what my lord would finally, because all these people, man, they were getting drastically, the salary has been now reduced. My lord. And in the affidavit, there is no policy decision brought on record.
Yes.
Subject to what my friend can show.
Yes, who is appearing for 123?
Yes, why not? The employer of the KVK are not the employer of central government employer. Already ICR is one autonomous organization. Or there are 23 KVK under AU Jorhat. And they are the employee under host organization Jorhat. This KVK are established under host organizations. Sub-host organizations are ICR, CAU, NGO. But the KVK employee of Jorhat are not ICR employee. So they claim 7 CPC under this allowance, they claim this allowance are only available where the employee of ICR. But already ICR and host organization AU and ICR sign a MOU and there is an agreement. It is clearly mentioned, Lordship, one circular, yes, here enclosed Lordship, page number 55, P2 annexure. In the circular, clearly mentioned, it has been brought to the notice of the council that employees of the KVK are filing court case claiming that the staff of employee the KVK established under the different host institution such as Central Agricultural University, Assam Agricultural University, non-government NGO. It is in this context, it is clarified that as per the memorandum of understanding and agreement signed between ICR and above mentioned host organization, it is clear that all the staff of KVK shall be borne on the establishment of host organization only. The administrative control over the staff of the employee under the scheme, therefore, shall be faced with the host institution. The ICR is only liable to pay only, and the salary in respect of the office staff required for the running of the scheme. It is a scheme, my lord. This scheme is terminated according to the authority of council. This employee are.
You are reading from which page?
Page number 55, main case, repetition 3964, two repetition here that 3964, 55 page number, annexure P2, my lord.
So, yes. So petitioners are not employees of ICR.
No, no,
Alright.
lordship. Our one memorandum, though understanding which signed by host institution and ICR, page number 47,
Then
annexure
the
1.
ICR is paying money for what?
ICR is a funding agency. It is clearly mentioned in the MAU, my lord.
To keep funding like before, that's all.
As a funding, it is clearly mentioned, my lord.
ICR is a funding agency. Keeps spending the fund like before. That's
No,
all.
no, lordship. It is clearly mentioned. Host organization is established according to rule and regulation, which is signed a memorandum of understanding by ICR and the host organization AU Jorhat. Under AU Jorhat 23 KVK, my lord. Some KVK are under ICR. They are available pay scale of the ICR pay scale. On the other hand, some employee of the KVK under host organization, they are not the employee of the ICR. Only ICR is the, my lord, funding agency. It is clearly mentioned. Page number 49, my lord.
Lost one.
49 of
In
which
exact
petition?
P1.
None of this present, 3964.
Yes.
Here, my lord, clause number 2 clearly mentioned, all staff of KVK shall be born on the establishment of the gratuity only. The administrative control over the staff employed under the scheme, therefore, shall be placed in the host institution. The placement of the staff working in the project under the termination of the project shall be sole responsibility of the gratuity. It is the responsible
Mr.
of
Nair,
the host
the
institution,
basic
AU, my lord.
dispute appears to be whether you are the staff of KVK.
No, I'm not even claiming that I'm the staff of ICAR. All those institutions that I have shown, my lord, the annexes that I have shown, all those are not directly under ICAR. They are under host institutions. My lord, they run it in three manners, my lord. One, they do it through agriculture universities. Two, they do it themselves. Three, they do it to NGOs. We are not directly run by ICAR. We are run by Assam Agriculture University. In Arunachal, it is by the government of Arunachal. In Karbi Anglong, my lord, Dima Hassan, it is by an NGO. All are being released this money. Only Assam Agriculture University under, because of that letter, we have been stopped. My lord will have page 49, my lord. It's clearly written there. Salary assistance in respect of competent scientists, technical staff in different disciplines based on local law so and so. Assistance for salary in respect of modest office staff necessary to support this scheme. So salary will be released by them, and that was being released to us, my lord. They have not denied that. Once that letter goes, my lord, the issues.
So now you are getting your salary.
I'm getting my salary.
Who is paying that?
ICAR. ICAR is paying it, my lord. My lord will have that. I just placed one document, my lord, wherein they have released that amount for May 2022. That was in 130 in the other case. Here, my lord, it would be. I'll just place that one. It will be 101, my lord. In 3964, it is 101. And in the other case, it is 130. My lord would have that 31/5/2022. Sanction is hereby conveyed to an amount of not exceeding so and so only under salary head for the period May 22 as detailed below. This money from my lord Indian Agriculture Institute comes here, and then the person here, he is making this my lord distribution, and they put this note here that DE Comptroller AU Jorat, you will not release the components with regard to the allowances. For all others involved here, my lord, have been paid these allowances. My lord would see who are they. This serial one, that page, serial number 2, ICAR RC for NEH region Borapani. That's an institution run by ICAR themselves. State Agricultural Department, Arunachal Pradesh. Again, not an ICAR. KVK Papumpare, not ICAR. KVK East Siang, not ICAR. Gwalpara, my lord, I think is ICAR. State Agriculture Department, Sikkim. KVK Dimahasa is by an NGO. The host institution is an NGO. We are not employees. We can never claim to be employees of ICAR. But this pay, the package is given by them. Because of that letter of some organization, they have stopped that.
Where is that list you just read? Which page?
My lord, 130, my lord, 130 or 110, 101 in my lord 3964.
In 3974?
In 3974, it is my lord 130. My lord, they give it to the various institutions who are there. And in the bottom, my lord, that arrow mark, my lord, would find they have stopped this only with regard to Assam Agriculture Institute. And that is in reference to that letter dated 2/5, which my lord would find at page 128, which is a result of that complaint letter.
And in page 130,
Lordship.
you are saying that serial number 2 is run by ICAR.
ICAR. 3 is by Arunachal Pradesh, which I have shown one of the pay slips, my lord. Contains everything. KVK Papumpare, KVK East Siang, KVK Gwalpara. Then 7 State Agriculture Department Sikkim, that is also controlled from here. KVK Dimahasa is under, my lord, a NGO. And they have been paid. And there is a clear cut here, my lord, because that amount might have included the areas also. They said, don't release this component to them. Why? Because of page 128. That is said to be now, my lord, the decision. Second paragraph, my lord. Subsequent to the above letter dated so-and-so has also been received from Sri Bolan Baishaw, president of so-and-so, which has been considered by the competent authority in the kind, has been decided to immediately stop payment of non-practicing allowance, special duty allowance, special compensatory allowance given to KVKs under the aegis of AAU Jorat from ICAR funds. My lord, if you have to stop it for all.
Yes, yes, yes.
Already, council start the inspection all the KVK employee for stopping this allowance.
No, what is,
Already I received.
what is
Count-
Hindu Yuva Satra Parishad
My-
got to do with this?
Already today I received this letter from council.
That is all right. What has Hindu Yuva Satra Parishad got to do with
Yes,
this?
they claim for allowance of this employee,
who
but
are
they
these
are
people?
not the employee of ICR. How they
Who
claim this
is-
employee, my lord?
Why, how this organization has stepped in? You tell us. This is a matter of institution. Assam Agriculture University plus ICAR.
Yes.
What has got Satra Parishad, what it has got to do with this matter? Hindu Satra
Already
Parishad.
clearly mentioned now, the allowance must be sanctioned by the
If you
ICR.
do
This
not-
grant is
if
not
you do
sanctioned
not
by
answer,
ICR.
I will omit it in my judgment.
This
What
committee,
has got Hindu Yuva Satra Parishad, what has it got to do with this matter?
yes, they take this step.
Why? On what basis? How are they concerned with these matters? Inside an institution, who is going to get which pay scheme? How is a Satra Parishad concerned with that?
Already Jubo Satra Parishad takes this step.
All right. You are for Agriculture University? Yes. I'll give you 5 more minutes and I'll dictate the order. You have to hurry up. We have other matters. We can't go on asking same question. What is your stand?
My lord, we are just forward party here. Because my lord, we are just implement the ICER scheme, my lord.
All right, take your seat. Then heard Mr. UK Nair, Learned Senior Counsel, assisted by Mr. H.K. Das, Learned Counsel, appearing for the read petitioner in both these petitions. Also heard Ms. Jupiter Das, Learned Counsel, Learned Standing Counsel, ICR,
Yes.
appearing for the respondent numbers 1 and 2, 1, 2 and 3.
120.
And Mr.
I Kolita. I Kolita.
I. Kalita,
4, 5
Learned
and
4,
6.
5, 6.
SC, AAU, Jorhat, appearing for respondent numbers 4, 5 and 6 in both these read petitions. Full stop. The read petition registered as WPC number 3974 of 2022 has been referred by the technical staff working in the Krishi Vigyan Kendras bracket KVK small s KVKs, whereas WPC numbers 3964 of 2022 has been preferred by some of the non-technical staff working in the KVKs under the Assam Agriculture University, Jorhat, being aggrieved by the order dated 2/5/2022 issued by the Under Secretary, Indian Council of Agriculture Research, bracket ICAR, bracket close, suspending the payment of a non-practicing allowance, special duty allowance, special compensatory allowance given to the KVKs under the aegis of Assam Agriculture University, Jorhat, from the ICR funds, based on a complaint filed by the president of Hindu Yuba YUBA Satra Parishad, Assam ASOM. Full stop. The case of the petitioners, briefly stated, are that they are all engaged in various KVKs coming under the administrative control of the AAU Jorhat, full stop, pursuant to the pay revision affected, central pay revision affected with effect from 1/01/2016. The petitioners were given the option to either opt for the pay scale of the state government of Assam,
Agriculture University or ICAR.
applicable to the Assam Agriculture University, or one applicable in case of employees coming under the ICAR. Full stop. Accordingly, the petitioners had opted for the pay scale of ICAR by taking note of the fact that although the grade pay was less in this under this pay scale, yet the employees would be entitled to certain additional allowances, such as such as
Non-practicing allowance.
non-practicing allowance, comma, special duty allowance, comma, special compensatory allowance, which would take the gross emolument of the employees higher than that receivable under the pay scale of AAU, full stop. The case of the writ petitioners is that the funding for release of salary of the petitioners is consistently being released by the ICAR, and accordingly, they have been receiving the ICAR pay scale along with the aforesaid allowances since 1/1/2016. However, with effect from the month of May 2022, the component of non-practicing allowance, comma, special duty allowance, comma, special compensatory allowance,
Traveling allowance.
and traveling allowances payable to the petitioners have been suspended by order dated 2/5/2022 in view of the instruction issued by the ICAR authorities by sanction order dated 31/5/2022. Those allowances have been stopped in case of petitioners who were the employees of the KVKs coming under the AAUs. Full stop. Aggrieved thereby, the instant writ petition has been filed. Full stop. The thrust of argument of Mr. Nair, learned senior counsel appearing for the writ petitioners, is primarily twofold. Firstly, that the aforesaid decision of the ICAR authorities communicated by order dated 2/5/2022 is wholly arbitrary, discriminatory, and violative of the principles of equality as enshrined in Articles 14 and 16 of the Constitution of India, inasmuch as the ICAR is continuing with payment of such allowances in case of employees of all KVKs coming under
Various host institutions.
various
Host institutions.
host institutions, including the government of Arunachal Pradesh, district authorities of Papumpare, East Siang and Gwalpara, government of Sikkim, as well as an NGO in Dima Hasao, while suspending such allowances only in respect of the KVKs coming under the AGs of AAU Jorhat. Full stop. Secondly, the submission of the learned senior counsel for the petitioners is that the respondent had issued the impugned notification dated 2/5/2022, acting on the basis of a complaint made by President of Hindu Yuva Chhatra Parishad, Assam, that too without serving any prior notice either upon the AAU Jorhat or the beneficiaries of such allowances. As such, the impugned order is hit by the principles of natural justice and administrative fair play as well. Full stop. In support of his argument, Mr. Nair has placed reliance on the communication dated 2/5/2022, annexure P/16, response of the AAU dated 26/5/2022, annexure P/17, and the sanction order dated 31/5/22, annexure P/18, close, annex to WPC number 3974 of 2022, to contend that but for the instruction issued by the director of ICAR, which led to sudden stoppage of the aforesaid allowances payable to the petitioner, there was no justifiable ground for the authorities to suspend payment of the allowances to the petitioner. Full stop. Mr. Nair has emphatically argued that due to the withdrawal oblique suspension of the allowances payable to the petitioners, their gross emoluments have drastically reduced, thereby causing enormous prejudice to the petitioners and their family members. Full stop. Responding to the above arguments, Srimati Jupitara Das has contended that the allowances are applicable only in case of those employees which are directly operated by the ICAR, those employees of KVKs which are directly operated by the ICARs, and not in case of such KVKs which are the assets of the grantee, like the KVKs coming under the AAU. Full stop. As such, the benefit of aforesaid allowances would not be applicable to the petitioners, in as much as they would only be entitled to receive the pay scale and allowances applicable to the employees of AAU. Full stop. According to Ms. Das, it was permissible for the president of Hindu Yuva Satra Parishad to make a complaint highlighting the aforesaid anomaly, and therefore the ICAR authorities have rightly taken cognizance of such communication and taken action in the matter. Full stop. The learned counsel for the respondent numbers 1, 2, and 3 has therefore prayed for dismissal of the writ petitions. Stop. Mr. Kalita, learned SCAU, has submitted that the university is merely the implementing agency, and if the funds are not released by the ICAR authority, it has no means to disburse the allowances payable to the petitioners. Full stop. I have considered the submissions made at the bar and have carefully examined the materials placed before the court. Full stop. There is no doubt or dispute about the fact that all the writ petitioners are working under different KVKs coming within the aegis of Assam Agricultural University. Full stop. It is also the admitted position of fact that the ICAR is the funding agency for operating all these KVKs, and during the previous years, the salary and allowances payable to the petitioners were disbursed from the funds released by the ICAR to the AAU Jorhat. Full stop. Full stop. The Respondents' Council have also not disputed the fact that ever since the year 2016 until May 2022, the writ petitioners have been receiving non-practicing allowances, special duty allowances, special compensatory allowances, traveling allowances, and traveling allowances. But in view of the instruction issued in the sanction order dated 31/5/2022, based on the order dated 2/5/2022, payment of such allowances have been stopped. Full stop. The materials placed on record goes to show that the impugned order dated 02/05/2022 has been issued without serving any prior notice upon the AU Jorhat authorities or the petitioners. Full stop. As a matter of fact, from the communication dated 26/5/2022 issued by the registered AAU Jorhat, it is apparent that the decision of the ICAR authorities as conveyed by notification dated 2/5/2022 was a unilateral one, and the same was contrary to the original decision of the ICAR authorities to grant allowances to the employees, which comes within the ambit of the agreement signed by and between the parties. Full stop. Full stop. Materials on record further suggest that the ICAR authorities have continued to release funds for payment of salary and other allowances, including those allowances indicated herein above. Even in case of employees of those KVKs which are not directly operated by the ICAR authorities. Full stop. If that be so, there can be no doubt or dispute about the fact that by the impugn order dated 02/05/2022, the respondent numbers 1, 2, and 3 have singled out the KVKs coming under the aegis of AAU Jorhat to suspend the release of whatever the allowances, non-practicing so-and-so allowances, as a result of which the gross emolument of these employees have drastically fallen and have continued to remain so till today, much to their discomfiture. Full stop. The learned counsel for the respondents have not been able to invite the attention of this court to any legitimate material permitting such a discriminatory treatment to be meted out only to the employees of KVKs coming under the AAU Jorhat. Full stop. On the contrary, it appears that the action having been initiated on the basis of a complainant who does not have any nexus with the operation of the KVKs or the ICR was based on wholly extraneous consideration and therefore cannot sustain the scrutiny of law. Full stop. Once the respondents have permitted the petitioners to draw a particular pay scale along with allowances applicable therein, and the amounts have been disbursed from time to time for over several years, the same could not have been abruptly stopped by the ICAR authorities by issuing the impugn communication dated 02/05/2022. Full stop. 22 without any justifiable ground. Full stop. As has been noted herein above, no legal justification is available before this court to sustain the impugn order dated 02/05/2022. Consequently, both the writ petitions succeed and are hereby allowed. The order dated 02/05/2022 is hereby set aside. The respondents are directed to release the so-and-so allowance to the petitioner for the current month, full stop, current month, and continue to do so until the same is modified in accordance with law. Insofar as the amount of arrear allowance is concerned, the same shall also be released to the petitioners in 3 installments within a period of 6 months from the date of receipt of a certified copy of this order. Full stop. It is, however, made clear that if for any valid reason the respondent numbers 1, 2, and 3 seeks to modify the pay scale and oblique or allowance payable to the employees of the KVKs coming under the AAU Jorhat, they will be entitled to do so only after serving prior notice upon the affected persons to be routed through the AAU Jorhat and after giving them an opportunity of being heard in the matter. With the above observations, these writ petitions stand disposed of.
Much.
That's it. Mr. Kohli,
22 Lordship. Just a minute only.
All right, let's see.
I'm obliged, Lordship. Lordship, we are giving the written submissions. You had asked on your order, specifically raised on para H and I. You will take us later, Lordship. I got it wrong.
Just 5 minutes. Let us finish this and we'll maintain this. You said you are leaving somewhere?
Actually, Lordship, I had a 3 o'clock committee meeting. I'm on that committee on the proposed law on polygamy. So, but Lordship asked me to stay, so I waited. I told them I'll be delayed.
Give one afternoon for the court also.
Lordship, with pleasure.
5 more minutes. that's
Yes,
it.
Lordship, I'm obliged.
Yes.
Lordship, this is that matter. The petitioners, they are the employees of the principal seat of the Honorable Guwahati High Court, and the grievance pertains to non-fixation of their pay scales in terms of the ROP 2017 after coming into effect of these of that rules. These are the set of employees, Lordship, who were
Let the principal secretary finance examine their grievance.
No, Lordship, so far as the first case is concerned, Lordship, that has already been, they have given the option, Lordship, that has been condoned. It was, in fact, option was given after expiry of the stipulated time. In the second case, Lordship, we have not received any proposal from the Judicial Department, Lordship.
Lordship, may I submit, part of our grievance has been addressed. The procedure that is mandated in the rules, in proviso to Rule 5, that has been.
Ms. Borgohain, I'm sorry to say, but then say things which can be sorted in next 5 minutes. Because obviously we can't hear and dispose of this matter today. What is that you want? Because these are the unfortunate realities. Full length hearing today will not be possible.
Then Lordship, a date may be fixed for a, because.
But what is it? He's saying the first street petition, the delay has been condoned.
No, the delay condone. The procedure that is mandated to exercise option that has been given to us, but while calculating the basic pay, they have left out the element of PSB.
No,
which is
what I was
exclusive
saying
to
is this court will never calculate the.
No, we are not saying to calculate.
Whom to send? You
No,
say we'll send it
No,
to
no,
that
Lordship,
person.
that has to be done in terms of the government notification, and that has been approved by judicial order. That has to be done. Only that remains in the writ petition.
So your grievance is with computation.
Yes, yes.
So we'll ask somebody to look into it.
Lordship,
What can
but
the writ
also-
court do about it? We can't
No, no,
compute.
in terms of the government notification that has been approved by a judicial order, they have to do it in accordance with that. Only that remains.
They have
That
not done
direction.
it. They have not
Yes,
done it.
Because even after they have done it, after the finance department has concurred with that procedure, the High Court has written to them that this is where you have erred, that you have left out the element of PSB.
What
They
is
have-
to be done now?
If your Lordship kindly takes up this synopsis.
What is the order you are seeking today?
What they have done is that while calculating the basic pay of High Court employees, the grade pay, the pay in payment, and the PSP has to be taken into account. While calculating the basic.
1 minute. What
Yes.
grade pay?
Grade pay plus the pay in payment plus the PSP.
Pay in payment.
Yes,
Plus
the principal sick pay. These three elements has to be taken into account while calculating the basic pay of a High Court principal seat employee. And on that, after they calculate the basic pay by adding those three elements, when the annual increment is due, they will calculate the annual increment on the sum total of these three elements. Now, what the finance department has, if your Lordship peruses that, the calculations we have annexed. What the finance department has done is that they have excluded the PSP and they have just taken into account the grade pay and the pay in payment while calculating the basic pay, and accordingly the increment, annual increment has been calculated on the sum total of only the grade pay and the pay in payment.
No, Lordship, my
That-
friend is
that
not
is the
correct,
error.
Lordship. Lordship, may kindly see my affidavit, Lordship. It has been categorically stated
that
as
element
such.
of- let-
One line, Lordship, I am reading,
Let me
Lordship.
complete. Lordship, the PSP will have to be taken into account because there is a government notification. In case of principal seat employees, these three elements has to be taken into account. And that has been approved.
how many
by High-
petitioners are here? How many petitioners?
22.
Huh?
22.
And there are two writ petitions. You know?
Yes.
I'm appearing here.
Personal assistant, everybody computer assistant.
All right. So apart from that, everybody else is getting
Everyone is getting, only this set of employees. They form the.
Why they have been left out? Why they have been?
No,
singled
no,
out?
this is the group lordship who were appointed prior to the publication of the notification, but subsequent to the date of effect lordship. I mean, date of effect
In-
was 1st of
in-
April 2016.
Hmm.
And the notice was, pay commission report was published on 17/3/2017 lordship. They were appointed in between this period lordship.
1st of April or 1st of January?
No, no.
Also
first-
April, yeah, April lordship.
Lordship, for these set of employees, in terms of the proviso to Rule 5, they have to be given the option to exercise. They have to be given the option to draw their pay scales in terms of the existing pay scales until they draw the next annual increment. And that option was not given to them. They were straight away, after the rules came into effect, these ROP 2017, they were straight away brought into the new pay band. So what the increment was not added to the pay scales which they were drawing. And as a result, they are drawing lesser pay. Lordship, the calculation, if your lordship kindly peruses the calculation for a moment there. And that has been
Ms.
done.
Borgohain, what I'm saying is, the court should not and will not give any opinion as to what should be the computation. It has to go to an expert. What is to be, what order is to be passed, tell me. This court will never say that you are correct with your computation.
Lordship, what
That
I'm
is the
saying-
order you are asking, that will never.
No,
come.
there is a government notification that has been approved by a judicial order. What happens to that?
What government notification? Which government notification?
Lordship, it's there in our pleadings.
Readings in which case?
And in the first case, Lordship. Lordship, if your lordship takes up the IA in the writ petition, that was not enclosed. Why we had to enclose it along with the IA, because lordship, there was a subsequent development.
Yes.
If your lordship takes up the IA page 28.
All right, these matters will take time, then we'll have to fix another date. It can wait.
Lordship fix a date, but
Huh?
Lordship, we are already waiting for the past 6
You
years.
may have to wait another 1 year. I can't help it. What to do? We
Lordship
can
will
keep
kindly
waiting.
peruse that notification for a moment, only that notification.
This court is rising at 3:30. There are some
Then lordship.
important
another day.
matters. 3:30 or 3:40 at the most.
Last time we got derailed by that writ petition, which is tagged with my, otherwise everything is.
What is? Yeah, but anyways, your matter will require a little cool application of mind. These are all calculations, pay scale.
Lordship, a very simple calculation.
Simple
And
order.
I'm not insisting that it should be heard today, as it is your lordship is writing early. I'm not insisting.
Not my sincere prayer, but that lordship will make it clear that they will file the affidavit.
I have received instruction, lordship, it's a single page instruction. That is the only instruction. That so far as the,
Do you have it in written instruction?
yes, Lord.
You don't have to file any affidavit.
Lordship, we are not going into the merit right now, Lordship, because if once we get the proposal, Lordship, we'll consider it, we'll examine it, then we'll take a decision.
Judicial department has not sent the, High Court has not sent the proposal.
I could have sent it. I could have
No,
sent it.
High Court has sent it, probably send it to the judicial department, but nothing thereafter.
Who is representing the judicial department? Ms. D. Borgohain, Learned Counsel appearing for the petitioners in WPC number. You are in which?
Item number 19, WPC 4464 of 22.
Also had Mr. A. Somo, Learned Counsel appearing for the petitioners in.
Second part.
Mr. P. Nayak, Learned SC Finance.
Finance Department.
And Mr. A. Chakravarti, Learned Government Advocate Assam are present on behalf of respond numbers 1, 2, and 3. What about you, Mr. Das? Mr. Das, you are for whom?
Yes. Respondent numbers
You can't take so much time to tell me.
3 and
who-
4.
Huh?
3 and 4.
3 and 4. 1 and 2 respectively, and 3 and 4. The grievance of the petitioners in both these writ petitions pertains to applicability of pertains to computation of their pay scale. According to the petitioner's counsel, the authorities have not correctly applied the grade pay, the correct pay band, as well as the principal seat pay applicable to the petitioners as employees of the principal seat of Guwahati High Court before fixation of their pay. And therefore, the petitioners have been compelled to approach this court by filing the present writ petition. Insofar as the primary grievance of the petitioners is concerned, Mr. Nayak submits that no proposal for review / refixation of the pay scale
In respect of the second case, Lordship.
of the petitioners in item 20 have yet been received through the judicial department. However, insofar as the grievance of the petitioners in item 19 is concerned, according to Mr. Nayak, their prayer has been accepted.
Yes, it was for condonation of the delay, Lordship. That has been condoned.
Their prayer has been accepted, and now the government has decided to extend the benefit of.
Lordship, so far as our stand is concerned, Lordship, one line, Lordship. As such, the pay of the petitioners is to be fixed as pay band in PB plus grade pay plus PSP.
All right, that's what she wants.
It is included, Lordship.
That's what she wants.
That is my affidavit, Lordship. And
Lordship,
same is the stand
calculation
of
is
the
not
High Court
correct.
also, Lordship. Judiciary.
So you notify them, you notify it. And accordingly, the pay of the petitioners would now be computed by taking into account the grade pay, the pay in the pay band and the PSP. Full stop. If that be so, the finance department should issue.
No, that notification, Lordship, will not be.
There. That is
That is already there.
While calculating the increment, they have excluded the PSP. That is where our grievance
So
is.
now he is accepting.
No, he's not accepting
No,
them.
calculation part, Lordship, we are not doing. Calculation will be done by the High Court, Lordship.
That is, High Court has written to them that this is the correct calculation. They say that we are doing it as per rules.
We have written to the.
We have written to them.
So he is also agreeable, he is also agreeable, everybody is agreeable, but nobody is doing
No,
anything.
the finance is not, finance department is not agreeing. Problem is.
So
They are not
if
admitting.
High
that
Court
there
has
is a-
written, you are accepting, then give effect to it.
It is already there, Lordship. Our part, implementation is
It is
not my job,
therefore
Lordship.
Provided that the respondent numbers 2, 3 and 4 shall now take steps for recomputing the pay scale of the petitioners by taking into account the grade pay, the pay in payment and the PSP with effect from 1/4/2016. And consequential benefits be given to them. Insofar as item 20 is concerned, 19 will be disposed of. Accordingly, WPC number so and so, you are not happy with that.
Lordship,
All
in
right,
terms,
you take one thing.
Lordship, in terms
So
of the.
and so, list these matters before any other bench without.
No, Lordship, just an observation that in terms of the notification dated 16/8/2016, unless and until their observation is there, they will again will again have to come.
We'll see some other.
That is,
Next matters, please.
Lordship will fix a date. Fix a date.
September 2nd, 7th September. Please take it.
Okay.
My lord, that electrocution of that boy, my lord, he lost both
What
of
has
his
happened
hands.
now? What is the status?
On the last occasion, my lord had desired a quotation, my lord, what will be the price of the robotic
What is to be
prosthetic?
done?
My lord,
Even something.
What I could see, my lord, that PHC department in the PHC, Carbon, they have filed an affidavit to the extent that he will be absorbed in service once he attains majority. Now he's 16. Next, my lord, an amount of rupees 4 lakhs was paid by APDCL as per their own regulations. Additionally, PHC department paid 5.2 lakhs to his parents. So if we now, my lord, fit the limbs, the best possible one, artificial limbs, and my lord, his future is ascertained through a job. I think that should be. I think otherwise, my lord, this is not a case to resist. Whatever, my lord.
No, that's
deems
right. But
appropriate.
what is the way forward? That's what I'm asking.
So that limb is to be fitted now, my lord.
My lords,
This limb will work.
this should work, my lords, because the same technician has worked on him before, my lords. Now he has come of age. So this should fit according to the.
Ms. Chaudhary, do you have anything to say?
Asked me to write it also for the constitutional law part, for which I have a brief note with my mail. I'll give it to your lordships. Again, so far as the compensatory damages and the constitutional law part is concerned. Otherwise, Asalsa and otherwise, which is not.
Salsa has nothing.
I'm just forwarding.
All right, so what is to be done today? What order is to? be passed?
Regarding this, my lord, they have obtained a quotation from a company, my lord. Let me verify through the health department for once, my lord.
Let them verify.
Once for the superior post, Guwahati Medical College, they have.
Hey, a glass is like khuli bodi bosa. Maybe we can look khuli bodi bo.
There is a medical board constituted also, my lord.
Earlier pursuant to your lordship's order, there was a medical board, that board has opined, but now what has come, I don't know. If necessary, I'll get back to the board.
Mr. Mohanto, do you have copies of?
I'll furnish a copy.
All right. Mr. P. Mohanto, learned counsel for the petitioner, has come forward with particulars of a prosthetic and orthostatic limb center, which according to him can come up with the prosthetic limb which would serve the purpose of the petitioner. Mr. P. N. Goswami, learned additional AG Assam, Mr. D. Nath, learned senior government advocate Assam, and Mr. B. Chaudhary, learned SC APDCL are present and submit that they be granted some time to verify the information and come up with adequate response. Full stop. You are appearing for whom?
He is.
Miss So-and-so, learned standing counsel KSC is present on behalf of our client. Miss R.S. Chaudhary, learned standing counsel Asalsa has appeared and furnished a brief note of cases which will be relevant in this case. Miss Chaudhary, however, submits that the Asalsa would not have any direct role to play in the matter. Full stop. You want to be? Really? If you want to appear, fine, otherwise we can. After going through the brief note submitted by Ms. Chaudhary and in view of the issues now arising for decision of this court is of the opinion that further presence of Mrs. R.S. Chaudhary would not be necessary in this case. Therefore, her presence is dispensed with in this case. Registry to re-notify the case accordingly after 4 weeks. All right. All right, you come. Please share the.
I've shared already.
But I got the copy of the estimate. I'm not on the amount, I'm on the just the materials which have been suggested here. I'll send it to the board and get their opinion.
All right.
Not the amount.
No, that's all. Amount is nothing.
Yes.
Who cares for the amount?
Correct.
All right, let's see if the efforts bring in some change in his life, quality improves. It will be good because at this stage of amputation, I don't think many people have got relief. But if he gets it, it will be nice. It will be nice. Yes. Please cooperate. Whatever you can.
Can there be a fixed date, man?
After 4 weeks as a fixed item. Yes.
May please, your lord. But you will kindly peruse order number 5/6/2023. 5/6/2023.
Yes. Yes.
Yes, my lord, only the petitioner was singled out and discharged, my lord.
What would you like to say on that?
We've lordship revised our written submissions and I'll take not more than 3-4 minutes. The sum and substance of it is the first being, this is not pleaded anywhere. This is also not prayed for. This was also not argued at the time of the written submissions. This is coming. And that we have quoted enough settled law, including a 5-judge bench, to say that this cannot be done. That's the first. Without prejudice, and it won't take more than a minute, Lordship. It's all in the written submission. Without prejudice to this fact, we've also, and we've given it in our written submissions, just given to the court. Without prejudice to this, Lordship, we are pointing out that he was arrested as the others were not arrested. There was a specific complaint in his case, which was under RTI showing discrepancies in his answer sheets, which was sent to forensic, and it confirmed it, which led to the complaint and the FIR, the arrest. So if he's seeking parity, it must be pointed out respectfully that his parity is constantly changing through this entire petition. He has sought parity with confirmed APSC employees who did not come in tainted. He is now seeking parity with those whose forensic, there was no forensic requirement. In fact, his parity is with the identical other lot who stand dismissed, upheld by the coordinate bench of this honorable court. And then, Lordship, we have gone on to all the other arguments that we did on the earlier stage, which is what is the public interest, that it has the thoroughness of the inquiry, etc. It's part of our written submissions. So that's the sum and substance of the entire thing. The only additional points were what I just pointed out.
All right. The written argument বিলাক এটা ফাইল কৰি দিছো। আগৰ কেছটো প্ৰিন্সিপাল চিটৰ কেছ কেইটা যে আছিলে বৰগোহাঁই আছে সময় ইয়াতে ডি বৰগোহাঁই এইটো দিছিলে এইটো তাতে ফাইলটো ভৰাই দিব। আগৰ ৰিটেন আৰ্গুমেন্ট নাই।
They filed, Lordship. We then filed the updated one.
So we can close the matter. Anything?
Depolitized, Lordship.
Make it CAB.
We take down. Mr. J. Patwari is learned counsel is present on behalf of the petitioner. Mr. N. Kohli, learned additional AG Assam, has appeared and responded to the new issue raised by the petitioner's counsel during his reply argument. As such, Mr. Patwari does not have any further reply to make today. As such, arguments concluded, judgment reserved.
Lordship, the last case, if I may take the liberty, that was really a touching case. I saw the visuals of that boy whose arms were amputated. And it was really nice to see that there's an attempt to see. Of course, we are way behind, but globally now technology is arriving, where sometime in the future it will be available here too, for the mind waves to actually help the limbs move. It is already under testing in the US.
Yes, will you just switch off the. Yes, who is appearing in this item 23? Yes, Mr. Marina.
My lord, it is for hearing, my lord.
Well, today we may not, there are some engagements, institutional engagements lined up. I have to rise a little early.
Well, 25 is also.
No, this is the problem, what to do.
Only pray, my lord, Lordship will fix a date.
You can take a date from him, but don't take it too short. If you take it too short, it will come as 27, 28.
No, we'll take a bit later so that it can be reached.
Give them a date. You take a date.
27 also not.
Any interim order operating anywhere till today?
Item 24, your lordship will give a short date. It is a matter of dismissal from service.
What date will give? You take it on Tuesday, but that day you will again have to take a date.
Lordship, subject to what my learned senior says. Lordship, next 2 weeks, Lordship, I'm tied down with the other states. I'll be moving to Mizoram and Nagaland. If it can be after 2 weeks.
No, the court has nothing to say. You can agree on a date and give it. I'm only saying that too short a date, because already there are 30 cases fixed on that. So it will come after the 30. That's what I'm saying.
Let it come, my lord, because he's a constable staying in Bihar, my lord, creating
That these are problems.
These
Mr.
problems
Raj.
are there.
There are
I think it-
hundreds